If I
I think you have to also, yeah.
Mic testing. Okay, it's picking up.
Okay, hello, hello, hello.
Yeah. Okay.
You want, we're on social media, so we appreciate if all of you can follow us on social media. Okay, so you can follow us on social media. These are some of the posts that we have done, like the 4 common myths about 4 common myths about will being debunked. Okay, so this is one of the things that you can look at it, share your client, or for your own information. Okay, you want to take photo of it? Okay, wait, just let me take photo. Okay, there. Okay, then this is our marketing team that's supporting all of you. Myself there. So I deal with the consultation, probably trust renewal workshop. So Sylvia is here with us today. She's taking care of the leads, client seminar support, executive club. And Glenson will be doing ESS website, social media as well. And Stacy will be support for extartation, renewal, revamp, and videos. Okay, so we are the marketing team. Annabelle is the head of the marketing team there on the extreme left. Yes. Okay, so for myself, what I aim to do is to work with ESPs regarding your own view or trust, or even your client query. If you have any that you're not sure how to answer, so that's where you can make a booking to sit down with me, either by Zoom or by face-to-face, to discuss all these things. Okay, so I also help you all to debunk your query about processes, Twinkle, how to use eWeave, you're not familiar. Okay, so that's my QR code. If you would like to make a booking, feel free. Okay. Okay, so I pass this time to Sylvia. Thank you.
Okay. So good to see all of you here. Thank you for being on time. Yeah. Okay, because we are still expecting a few latecomers. Yeah. So thank you so much for being on time. Okay. So I just share with you a few ESP events, public events, and also a new feature on Twinkle. Okay. So for ESP's workshop, okay, we have 3 now. Okay, so first one will be Essential Sharing Series, which if you are in the broadcast, right, we will have received our newest session on estate administration case studies. It's on 15th of April. You all can go and sign up. It's also a small fee of $10.90. Okay, and then this will be conducted by our staff and industry partners. So previously last year when we launched Essential Sharing Series, we actually had Mr. Liu Heng Kwan, a tax expert, to talk about ABSD and 99-to-1 rule. Okay, we also have, for this time, we will have our own staff, Bruce and Kwan Chun from the Estate and Trust team. They will be sharing about what happens after death, what is the estate administration process. Okay, and then next one, Extartation Workshop. It's actually a workshop led by our experienced ESPs. So we will be having a session in June. That's by Anjali. She will be talking about meaningful farewell, so which means life after death. Okay, yeah. So you can also sign up. These workshops are at a small cost of $10.90. Okay, and then the last one will be Elevate Workshop. Is the one that you are here today at. It's a hands-on will writing workshop, and it's led by John and Frankie. Okay, so for an overview of the ESP events, you can actually go to presetsgroup.com, and then under the practitioner tab, ESP events, you can actually see an overview of the events we have, and you can register over there. Okay. Okay, so as I mentioned, so Elevate Workshop, today's session, and Essential Sharing Series on 15th of April, and then we have Extartation Workshop on 19th June. It's all 2 to 5 p.m. Okay, so next one will be Client Acquisition Focus. So firstly, we have the public seminar. So we'll be having one on 17th of April in Hokkien and Mandarin. It will be conducted by one of our experienced ESP, Roger. So this is actually the first time that we have it in Hokkien. So if you have clients who are more well-versed in Hokkien and Mandarin, do help them to sign up for this workshop. The broadcast is actually sent to you guys already. And why, as you can see, you know why there's no QR code or link on the flyer itself. Because we want you to register for your clients. We want you to invite your clients to our seminar. And then when let's say your client wants to do a consultation, the lead actually goes back to you. Okay. So the next one, if let's say your client is more well-versed in English, it's on 30th of April. Okay. So both session falls one day before the public holiday. Yeah. So you can get your clients to come because next day is public holiday, you don't need to work. Yeah, so you can come. Okay, it's 7 to 8:30 p.m. 1.5 hours. Okay, and then after public seminar, we also have one that's Craft Your Legacy. So this Craft Your Legacy workshop is actually for clients. So when you as an ESP already attended this Elevate workshop, you already know what are some things to look out for. Craft Your Legacy is for your clients to know what to look out for. And you as the ESPs can bring your clients, sit down with your clients and explain to them, guide them through the process of who should be your executor, how much should I give my beneficiary? Should I give them in one lump sum? What other ways can I help them in the future? Okay, so the next workshop will be on 9th of May, 7 p.m. So this is a free workshop for clients. Yeah, so you all feel free to, you can scan the QR code, and then if not, we'll broadcast this session also, then you can just register for your clients. Okay, once again, this workshop is also led by John and Frankie. Okay, so overview of the public events, you can always go to our website, or you just go presetsgroup.com/events. So then you can take a look at all the events over there. Okay, so just an overview. Okay, so as you all can see here, for ESPs, we have 3 workshops, and then we usually, if you are in the executive club, we'll actually host executive club meeting as well. Okay. Then those highlighted in yellow is actually new. So Elevate workshop is new this year, just launched. And then for public, we have two public focus now. One is Craft Your Legacy, and after that we have the public estate planning seminars. Okay. And then for this, the next one, the one beside highlighted in yellow, is actually the Hokkien seminar by Roger. And then we do have a Indonesia in Bahasa Indonesian by one of our estate and succession practitioners, experienced one, Adi. Okay, so if you have Indonesian clients who wants to understand more on how they can plan for their assets, you know, because Indonesian, sometimes their tax law, right, is quite different from ours. So Adi will be going through in Bahasa Indonesia to let clients understand how much they can plan and how furthermore they can plan for their descendants. Okay, then we do have other external events, and we are actually planning to launch Craft Your Legacy in Mandarin. So do keep a lookout for that. We are trying to get one in Mandarin. Yeah. Okay, so last part for me before I move on to pass on back to Frankie. Okay, so for Twinkle, we have a new add-on, room booking. Yeah, have you all tried out the room booking yet? No? But you all did receive a broadcast on the room booking new feature, right? Yeah. Okay, so for this feature, right, it's actually just added to the top bar of it. So beside the chats, you will see bookings. Okay, when you go into bookings, then you can choose by the date and time, and then number of hours you need, and the number of people, and then whether you need TV. So a room will auto-populate out. Okay, then you can just put your client's name, what's the purpose of your booking, and then any remarks if you need, then you just book. Okay. Yeah. So that's but even though there's attestation there, right? But note that you should still give your attestation dates to the Wales team first. They will do the booking for you, and they will let you know whether it's available or not. Yeah, so don't book attestation for yourself because limited hours only. You also have quota, so don't use the quota for attestation. Okay? Use for consultation or other meetings, trainings, etc. Okay. Okay. So when you press confirm, then the email will be sent to you. Okay. Yeah, then you can see your upcoming bookings if you have when you click on bookings, then rooms. So you'll see your quota, and then after that you can also see the bookings. Okay, so back to Frankie.
Thank you.
If you all need any help for room booking, just
Okay, so moving on, there's an additional thing under the resources tab. It's not new, but if you haven't known about it, there's a thing called schedule of assets. Okay, so we're going to talk about that.
I'm using this way.
So if you have not heard about it, this is quite an important document for your client, especially after they pass on, because you need to have this written up before you can apply for grant probate.
So updated.
You have one in your hand also. Yes, very nice, very nice. Okay, so the very colorful booklet, or you can use the online version, which is the PDF version, and then you key in and then can print out. Okay, so just let you know. Okay, then And another note is about the payment for your client. If they want to do a will review or they want to do a trust, you can always go to the online payment under precisegroup.com deposit. So you just select precisegroup.com, select this thing, practitioner tab, then deposit payment. Then that's where you can access the online payment to make for your client the online deposit payment. So this is how it looks like after you go in. Okay, this is the balance payment link, because sometimes your will can be above certain amount and it's not in the standard amount that you have for the
This is not
16 clauses or
interesting,
and 17 clauses and above. So that's why you need to have this balance for payment.
It's good that I forgot to include the screenshot of this.
Okay, so who have heard of Provi Trust? Have you heard of Provi Trust? Okay, who never heard of Provi Trust? Don't raise your hand. Okay, so okay, never mind. So you all know that for will, right, everything can go into the will except for CBA money, right? So this Provi Trust is designed to handle CBA money. Okay, so how does it work? Okay, before we go on that, so for Provi Trust, there's a currently there's a discount going on, because for Provi Trust, you can appoint individual trustee or a professional trustee like us to handle the CPF money. Okay, so to give on a periodic basis, just like a trust. So if you appoint an individual trustee, currently the price is $300, but if you appoint us, it's $800. This is before GST. Take note. Okay, so this is the pricing. Previous price. The blue one, next time the promotion for those clients who don't have any will or custody with us. So the price will be,
Yes,
436 or 1526. So individual trustee is 436, professional trustee is 1526. Okay, so this is after the $100 discount. And then for those existing client or new clients, if they take out a will on the as well as the trust, then the pricing will be 327 or 872. You notice it's quite a significant difference.
Yeah, so
half of the professional trustees like
I do.
Okay, so we appoint us.
But actually, I'm in the meeting right now, so
for existing clients and new clients. This is the
try calling me
discount
tomorrow.
you enjoy. Okay. So this is the website under digitaleppplasia.com. So as you can go to the provitrust.com website. So what you can do is, if you want to try out how it works, you go to this website, then there's this thing, create account. Okay, so you create account for yourself, then you go and try out and see how it works. Okay, so basically, this will be able to direct how your CPF fund will flow into the will. So for example, before you meet your client, right, there's this form in the Twinkle, Provi Trust application form. So you can use that as a guide to get understanding from your client what they want to do with their CPF money. Whether appoint professional or individual trustee, give how much per month, right? So you fill out that form first. Then once the client have an idea, then you log into the portal. I mean, your client log into the portal to apply for Provi Trust. Okay, so it's basically online portal application for Provi Trust. So this where in a diagram how it flows in. So you have your will, imagine, and then you want to handle the CPF money. So you can appoint either through the Provi Trust, so you can appoint either individual or professional trustee to handle the CPF money. Then you flow back into your will. Okay, that's how it works. Then the Assured Trust is something that's up and coming. We shall let you know once it's launched. Up and coming, huh? Oh, sorry, this one not yet. Okay, so you all know why you're here today, right?
Pre-planning on
okay, Elevate workshop, huh? So it's not just about learning, but also for you to write your own will. That means do your own will. You have not done so at the end of the workshop. Okay, so hopefully you can do that today if we can. Okay, so before I bring on the speaker, John has been our trainer, also our senior ESP for a long time, and he's very experienced in this area. So today we're very glad to have him to come and share with us, will writing. Come, let's welcome John. Thank you.
Thank you. Okay, thank you for coming for this session. Just take. You turn on the mirroring first. Oh, it's already on already. Prism got this funny problem. It's really sharing. I turn it off first and then try turning it on again. Try. Connect. Detect a small signal. It's really detecting as a monitor. Okay. No, cannot transfer the thing. Okay. Yeah, we did. Thanks. Okay, sorry, we wait for some technical issues to be sorted out, like Murphy's in the house as well. So maybe I just start off with the introduction of what this course is about, or this session, Elevate Workshop, and roughly what we're going to go through. Okay, so in this session, the main objective is that the two key things I'm trying to cover in this session to level up everybody, or rather, as we said, to elevate the positioning of all the ESPs over here. So there are two key things we're kind of trying to do in this session. The first of which is to have an opening conversation. How do you have an opening conversation with the client? Essentially to deal with the pre-sales. And in this first engagement that you have with the client, the end goal is for you to close the case in that first meeting. So I'm going to share a little bit about what I typically do as a script. Now, there's no such thing as a 100% foolproof where you run through these steps, 1, 2, 3, 4, 5, you're going to close the case. Obviously, it depends on a whole lot of factors, including the readiness of the client, right? But the point is that if the client is ready, then you want to improve your chances of closing that case. I'm going to share a little bit about what we want to do in terms of the workflow. Then the second part, and perhaps the more important part of this session, is to get all the ESPs here who have not done their wills to do their wills first. So what we're going to do is kind of like a mass fact find, where we'll go through some of the materials. I have some handouts to give out. These are still work in progress, so it will still likely change before the final version is out. But it serves as a basis for you to do some basic pre-sales and fact find with the client to help you understand the situation that the client has, and more importantly, what do we actually do when we're going through the planning with the client, right? And hopefully at the end of this session, each of you, if you've not done your will yet, and maybe a quick show of hands here, how many of you have not done your will? The ESPs. Okay, so some of you have not done that. So then this session will be particularly useful for you. For those who have already done your will, it may be a good time to also go through this process again to see how it works. Okay, great, thanks. Okay. Oh, I think it's off, sorry, hang on. Okay, good. Thanks. Okay, so it's also to go through the actual planning process. You get to see how it works, or at least the way I run it at least. And I've been doing this for a couple of years. Again, it's by no means the one and only way. Each of you may have your own style, but at least that's one method that you can use. And it basically covers about 5 key things that we want to go through with a client, right? 2 appointments, executors and guardians, and then 3 forms of distribution: residuary clause, specific gift, and testamentary trust. So if we just keep these 5 things in mind, we don't actually need any hard copies. I mean, for me, I've done it often enough where I can literally write out these things on the spot And I think it's not very difficult. It doesn't take a lot of power or brain power to memorize that. And if you keep that in mind, the wheel planning becomes a lot simpler, a lot more straightforward, and a lot more focused. Okay, so we're going to practice doing that in this session. And then if time permits, I have 3 hours, and I tend to overrun my time, if those of you have ever attended one of my training before. So if time permits, we'll do a bit of a role play practice of some of the things we've gone through today. In particular, the pre-sales conversation, right? We're going to practice a couple of different things, right? So with that, let's run through what we're going to cover. First part, we're going to talk through some pre-sales conversations. How do we have an opening conversation with the clients? Okay. Now over here, I'm going to assume that these are all cold call. That means these clients have not reached out to you. They don't realize they need estate planning right now. So it's going to be a cold call case, and we're going to practice. There are a couple of things that we want to go through. Now, what I don't have really is a script, as in I'm going to give you step 1, you say this, step 2, you say that. I don't really have that. But rather what I'm trying to do in this session is to give you key pointers or key checklists of the things that you want to be able to articulate to your clients, right? And why you want to do that as part of this pre-sales conversation. And the end of this pre-sales conversation, right? And this could, for me, when I do this with a call of a client, 15, 30 minutes, and I either close the case or I don't. I mean, there's only 2 outcomes, right? But more often than not, if the client is ready, right, you are able to close the case. And when I say close the case, it means that the client is ready to make the deposit, sign the LOE. Okay. Again, it's by no means 100% foolproof method, but I think it covers the essence of what we're trying to get to convince the clients to get their wills and estate plans done. Okay, so that's the first part. Then the second part is again to do the actual planning, right, for yourself. So once we close the case, we move on to the next stage, and I will show a brief 6 or 7 step workflow that I have. We won't be going through all of that. That's probably a 1-2 day workshop in itself. But in this part here, we'll go through some of the planning, the 5 things as I mentioned earlier to get your own wills done. And so for those of you who have not done your will, then it's a good time to think through that. This is sort of the conversation I typically have, the fact-find conversation I have with the clients, right? And maybe while I'm prepping to get to that stage, at this point in time, it would be a good idea for you all to list down some of the stuff you have, your assets, list down who are your potential beneficiaries. So if you find some blank space somewhere and some of the handouts that you have, you can list down the kinds of assets you have, at least the broad categories, right? You have insurance policies, you have investment accounts, you have bank accounts. List down what these items are, the broad categories. List down who are your beneficiaries, who do you want to give to, parents, siblings, spouse, children, uncles, aunties, government, okay, probably not, but whoever else you want to give to. So have these two lists with you, because when we get to this part about planning your assets, we'll be going through, you'll find that it's very useful to have that in mind. In fact, that's really what I typically have get my clients to prepare before I meet them for the fact-find session. Otherwise, it will not be very productive. Okay. And then if time permits, we will do a bit of practice, right? We will simulate the pre-sales conversations. In this case, I will get some volunteers, or at least I will volunteer you if you don't volunteer. And then I will simulate the client, and your job will be to run through about 4 or 5 things that we handle in the pre-sales conversations. How do you start that conversation? So we will practice a little bit about that. And then I'm going to throw some questions at you, pretending to be the client, and then your job will be to convince me that I need to get my estate plans done with you. Okay, and then we'll conclude with the session, and that should take us all the way till about 5 o'clock. Okay, so with that, let's start with the first part, estate planning opening conversations. Okay, now for me, I have this journey that I imagine that I'm going through, and there are, I think, 6 or 7 steps. I can't remember offhand right now, and I'm just going to do a quick introduction about what these steps are, and you can use that as a reference as well in terms of how you think about the customer's journey that they're going through with you. So what we're going to be focusing on today's session is the first contact, or the pre-sales conversation you have with the clients. That means the first time you talk to the client, they are not your clients yet, they are a prospect. What do we need to say to convince them to become our clients, right? So that's step 1. Then after step 1, we get to the fact find prep. So at this point in time, the client has already signed the LOE or paid the deposit, or at least paid the deposit, right? Because LOE can still do a little later, but if they paid the deposit, then they are definitely your client, okay? So at this point in time, there's a couple of things you want to prep. You will send some information to the clients to get the client ready for next step, which is the fact find itself. So this is where, this is my actual first meeting with the client. Usually when I meet, for the first contact, I would prefer that first conversation to be virtual, at least, or phone call at least, right? I try not to meet the person yet, unless we happen to be together, but I will try, because of efficiency of time, I try not to do that in person. It takes a lot of time to travel there, parking, and all that kind of stuff, right? So I try to do that virtually, either a phone call or through online conferencing software like Zoom or Teams or whatever, okay? So the fact find step 3 is really where I first meet the client, right? But the prep, the step before that is important, because if we don't go through that prep, I won't be talking so much about that. But the gist of it is to get the clients to do what I just told you to do, right? List down what assets they have, list down who the beneficiaries are, because if they haven't done the exercise, and I ask them to send that list to me. So I have some documents which I send to the client, get them to fill that in and send that back to me. And to me, that is a checkpoint for the client to be ready to meet me, right? If they haven't gone through the exercise, I don't bother meeting with them because they are not ready. Because if you meet the client and you do the fact find, you ask them what assets they have, they cannot really remember, they don't know whether the property is jointly owned or not, they don't know whether they have overseas assets, who owns the assets. If they're not ready, then you can't really have a meaningful fact find, okay? So we'll be practicing the fact find and in today's session as well, at least a shortened version of that. Okay, so that's step 3. Then step 4, this part onwards, I'll just move through a bit quicker because we won't really be going through this. But in step 4, after you've done the fact find, a couple of things you follow up with, typically getting the details that you did not get in the fact find. So in the fact find, there are a couple of key things I get, and those are not things like your NRIC, the full name of the client, and stuff like that. So the details will come as part of the will execution prep, because after that we are filling in the EWF and sending that in. And then eventually this part will ding dong a couple of times until you get the final draft ready to sign. And that's the will execution. So this is where you probably meet the client in person for the second time. So in my workflow, we have 3 points of contact with the client. The pre-sales meeting, which is usually virtual, if possible. Then 2 in-person meetings. One, step 3, where we meet the client to do the fact find, right? And this could happen more than once, depending on how complicated the situation is. But if it's a straightforward will, then probably single meeting, you gather all the key information you need. Then the second time you meet the client is the actual signing of the will itself. So will execution, that's step 5. Okay, then step 6, you have an annual review. The client may meet up with you as part of for many of you in the financial advisory space, you can meet up with clients, get their updated asset list. There's a couple of other steps you can follow up on, their custody service, and potentially, if you've done step 1 properly, you have the possibility to follow on with other execution of other tools, right? Maybe an LPA, maybe a trust, and so on and so forth. So we get to step 7, where we potentially implement other tools. So this is roughly the steps that we go through, or at least I go through with me and my team. Okay, so let's go back to step 1 again. In the pre-sales conversations, what do we do? So there are about 4 things that I typically try to do. The first of which is position yourself, okay? Now, each of you will have to think about your own positioning. This is roughly what I do for myself. I will explain roughly what I do, and you can use that as a reference, but you probably have to craft that on your own. In step 1, or rather this first part, positioning yourself, is about helping the clients to recognize that you are not just a one-trick pony. You are not just a regular financial advisor trying to sell the next insurance policy. You are actually a comprehensive planner, right? At least that's the way I position myself. But each of you who have to think about what you're trying to do, right? We'll go through that in a bit more detail. Then the next thing we're trying to achieve is to help the clients recognize they have a problem. So if this is a cold call case, most clients would probably have not done their wills at a starting point. And so they may have a lot of misconceptions about why they have not done it yet. And so your job in this case is to convince them or help them recognize that they have a problem, right? Because most clients don't recognize they have a problem, and that's why they have not got their estate plans done yet, right? So we'll give you some strategies on how to do that in the following slides. Then the next part is, okay, once they've recognized they have a problem, they need to know how to solve the problem. And this is where your initial positioning and how you convince the clients that you, together with Precepts, are the right solution parties to help them solve the problem that you've created for them. I mean, it already exists, you just surface it to them, right? You want to position yourself to be the right party to solve that problem. And then the last part here is to tackle any other objections and myths that they may have, misconceptions, and we'll go through a couple of them. And it's not a comprehensive list, but it's some of the more common ones I've seen. Okay. So that's roughly the 4 things that we want to do in our first meeting. And as I said, hopefully at the end of this session, the clients will be ready to sign with you and at least pay the deposit and become your client. Okay. So over here, I'm making an assumption that everybody here is a financial advisor rep. Anybody who's not a financial advisor rep here? Nobody? Or you are not? Okay. So it's still okay. You just have to think about your positioning a little bit differently. And if you need some help during the break or something, we can dialogue about it. But what we're trying to do in this first session is that you're trying to kind of lay the groundwork to highlight that you help them identify what are the different services you're able to offer to the client. Okay. So for this part, I've simplified the positioning for advisor. So there are 4 things which I typically position myself at for those in the financial advisory space. Again, you can craft your own message. But what I'm trying to do here is we first talk about income prioritization. You are an expert in managing income, right? Helping the clients, it's a fancy way of saying budgeting, essentially. Helping the clients to identify what parts are important to them to be able to allocate their limited resources into areas that make the most sense for them, right? Whether it's buying a new policy or investing for the future, for their retirement, whatever else. So you position yourself as income prioritization. Then you can talk about insurance planning, right? You are a protection expert, and so you want to be able to highlight to the clients that you can do that. Then if you are able to do investment advisory as well, then that's where you can position yourself to be an investment portfolio manager, to manage the client's portfolio, to save for retirement, save for children's education, save for whatever other goals they have. How do we use the different tools we have? And finally, to highlight that we are handling inheritance purposing. How do we purpose all the assets we have to transfer to the right parties? Okay. And what we're trying to do in this case is to help the client realize that we're not just trying to sell insurance, right? And at least for the FARs, you're not just an insurance guy, you're not just an insurance salesman or not an investment salesperson. You are a comprehensive financial advisor doing planning for your clients. And the planning we're doing is from budgeting to protection to investments, as well as estate planning, okay, or legacy planning. So this, again, frames your positioning in the client's mind that you are not just a one-trick pony, you can do quite a number of different things. And how you want to position yourself, again, depending on your roles, think about it. This is something I do for myself, but this helps the client realize that right now, they may be talking to you on the inheritance portion, right, the estate planning, but by highlighting that you can do all these other things, it gives you opportunities for them to come back to these other areas so that you can come back to get them to do their insurance planning. They realize that if I identify a particular need under the inheritance portion, I realize I have a overseas mortgage I didn't consider, right? I can come back to the protection part to deal with it subsequently, and you can do that for them, okay? So that's the positioning part. It helps you realize, or helps the client realize, you can do quite a number of different things, okay? So, yeah, then you become the star and the champion. Okay, now for those of you who are not in the financial advisory space, if you don't mind me just asking, if it's not too private, which industry are you from? Okay, and for estate planning, are you doing this as a sideline, side hustle kind of thing, or more for your own need? Okay. So again, depending on your position, if you're doing it as a business, then you got to think about what's your value proposition to your potential clients if you're doing this as a business. If not, then I guess there's no positioning. You're just thinking about your own needs. So right.
Earlier will did many years ago was not to what she wants at this point.
Right.
So she actually wanted to change the whole will altogether.
Okay.
So,
Definitely. Yeah. Just like financial planning, you don't do your financial plan once and then you forget about it, right? Because things change over time. Individual situations change. Your beneficiaries may pass on. Your executor appointments or your various appointment holders in your estate plans may change, may decide not to do, may pass on, and so on and so forth. So your plans will have to evolve. So it's not a do once and forget kind of thing, right? You do want to make it as robust to be able to respond to future changes as far as possible, as within reasonable limits. But it does, changing it over time definitely is something that will happen, right, for most people.
this whole kind of definition. Pass away, who is going to handle it? So they thought it's just a straightforward, okay, I do my will and then that's it.
So that's a good point, right? If the client tells you, I already done my will, okay, it's not covered in this particular training, but don't take that as this is not my client anymore, right? And in fact, this script still pretty much applies to that situation because all you need to do is help them realize that they still have a problem. Because it could be because their wills are not reflective of their current situation. That's a typical example. Or the other case, and more likely the more likely case, unless they've done it with a professional firm like Precepts, more likely the case, the will they did is very simple because they had no idea what they're planning. They fill in a simple form and the lawyer drafts it based on that form, but it doesn't address a lot of their unique circumstances. So once you help them realize that they still have a gap, which is step 2 of this conversation, they can still be your clients. So don't give up even if the client has a will, right? In fact, ask a couple of questions and more likely they realize, hey, my will doesn't address my situation adequately and therefore I still need to revise it, okay? So the conversation is still applicable. So again, in summary, positioning here is about how you highlight what you do as a estate planner. We're not just an estate planner. In fact, for me, my positioning is, even though I'm a licensed advisor rep, I never highlight that as a starting point. I'm always an estate planner first, right? Because partly also because nobody likes to talk to a financial advisor rep, right? The positioning always is, I'm going to sell you insurance or investments. And that's a very hard conversation to start. If you're dealing with the wealthier individuals, then they're also well invested, well protected. But starting as an estate planner is where you can, it's greenfield to a large extent. People are unaware of the problems they have. It's a lot easier conversation to start, but it links back very much to the financial advisory as you go through the planning. So that's a nice benefit. Okay, so that's estate planning. And so the other things to be aware of is that estate planning is a very broad topic. Right? At Precepts, you always say we start off with the will as the cornerstone for your fact find, but this is where you can find there's so many other areas. And to save time, I won't go through them. You can snap a picture or whatever. This is not meant to be an exhaustive list. There's so many other areas that you can talk about. And so these are the different things you can hide to clients, right? As an estate planner, I can do potentially all these different things. Digital estate planning, helping you get your LPAs done, tax, having a discussion on tax planning if you have overseas assets, knowing some basic rules, linking that up with the appropriate service provider to solve that problem. Again, we are not tax advisors, for example, but then working with other parties or lawyers that can do some of the other parts in terms of the tax planning or drafting of other kinds of the documents like shareholders agreement and stuff, all that to me falls under the broad umbrella of estate planning. Okay, so part of positioning is to highlight that these are the different things that you can do. Right? It does take time for you to build up this set of skills and knowledge. So it's not going to be something you can position overnight. But among this list that you have here, which are the things you want to focus on, and then attend classes, learn a little bit more about it, and slowly build up your expertise in these areas so that you can have a broader range of services to offer to your clients. Okay, I'm not going to go through each of them to save time, so just going to go through quickly. Okay, so the next part, we've covered our positioning. So the next thing we're trying to do at this point in time is to help the clients recognize that they have a need, right? And so this diagram I have up there is that I consider all clients a walking time bomb, right? It's walking time bomb in the sense that they don't realize they have a problem. And so the moment they die, the time bomb explodes and all their family members, the surviving family members are affected by that explosion, and they are the ones that bear the consequences of that inadequate or lack of planning, okay? So there's so many different areas to consider, right? Financial immaturity of the client, growing affluence of the client base, there's mental health issues, mental incapacity issues, guardianship issues, and there's so many different areas to plan for. Any of these are areas where you can help the clients recognize that they have a problem. They just don't realize it yet, okay? So estate planning really is about recognizing what issues and problems the client is faced with, and then using the appropriate estate planning tool to address those specific needs, okay? And so I have a list of different tools over here. We talk about wills, trust, LPA, joint ownership. And this is again not an exhaustive list. There's so many other things that can potentially be included in terms of your estate planning. But this is where we help the clients recognize that all their wishes, their desires, their goals, right? If you want those distributions and wishes to take place, then they need to plan for it, and they need to use the appropriate tools to ensure whatever they want to do happens, preferably in a legally enforceable way, right? More often than not, many clients take the simple way out and they simply say, I'm going to pass everything to my older son and he knows what to do, right? And that's not estate planning, right? We don't leave it to chance. We don't leave our intentions and wishes to somebody else to execute. By using the appropriate tools, this list over here, we can ensure whatever we want is legally enforceable. We give the beneficiaries, the people we care about, a legal recourse if they don't get their rightful share of whatever estate and assets they have, right? So that's the core of estate planning. Many people tend to leave it to other people to decide for them. The point is, as estate planners, we need to help the clients recognize, please don't leave it to chance. Don't leave it to other people to decide. That's where all the problems happen, because when the other people cannot agree or disagree on how things are supposed to be handled, that's where all the fights happen. And that's why we have case studies to read in our training material, right? So the point here is we talk it out with the clients, help them recognize that it should be them that decides. It is their assets, their beneficiaries. And so we want to document down their intentions in a legally enforceable way using this set of tools, and make sure that they're all properly aligned, right? Another typical problem is that they're done at different times, like your insurance nominations are done over many years because you buy insurance over a period of time, but they never go back and they never review it. And so some of the policies are nominated to parties that are maybe not so relevant at this point in time. So it's about keeping it updated and making sure that they're all aligned, saying the same thing, okay? Now, the challenge with estate planning is because some of these things, not all of these things are commissionable, right? And that's where the potential problem is, right? You can spend time working on, for example, joint ownership. How to get paid for joint ownership, right? You can't. But at least helping the clients recognize that they should consider, right? If you have joint properties, joint bank accounts, joint investment accounts, do you intend to give those assets to the people or not? If not, then please break the joint ownership. Otherwise, it by default will go to the surviving party. And if other beneficiaries want a share of it, they will have to potentially challenge, go to court, and it's costly and probably very ugly, right? So again, it's about helping the clients recognize that there are some parts that they have to do, some parts we as an estate planner will do, and we need to work with the clients to achieve the desired outcome, okay? Okay. So the way that we help the clients recognize they have a need is to surface a problem that's very relevant to them. In this example here, or in this training, I'm going to highlight 3 very common scenarios, right? But if you go back to the Precepts IBF course, right, the 3 days course that we went through under the wheel section, there are a lot more other scenarios to cover. Here, I'm going to pick out 3 ones to highlight, and to me, these are the perhaps more common scenarios. We should probably work for most clients you encounter. But the underlying principle here is that if we can bring up a particular problem, the more we know about the client, we can bring up a problem that's very relevant and close to your heart, then it's going to work a lot more effectively, right? But if you don't know the client, right, cold call case, as I mentioned, you have no idea what scenarios they're facing right now, then pick some of these generic cases, and it's a good starting point. If you are able to talk to the client more, or they are your existing clients, and you know their circumstances more, bring up one of the more relevant ones, okay? So the first starting point is we talk about the situation where there's no wheels, okay? So if they don't have a wheel, then what are the problems they face? We'll talk a little bit about, if you recall, talk about the problems of intestacy distribution. Right? You have no discretion. I always call it a lucky draw of whoever survives you. Right? There are also problems with dealing with the administrators and the need for surety. So we'll cover that in a bit more detail. Then the next part is talk about real estate, right? And here we drill down specifically to HDB. Right, so we'll highlight to the client, do you have a HDB flat? The client says, yes, great. Bring up this point and help them realize why it's so problematic to deal with HDB. Right, we're going to look at that in more detail. But if you go back to the precepts notes, we extend the discussion to not just HDB, but talk about real estate in general, including private property. It's also problematic. Okay, so we talk about real estate. And then the last part here is we bring up the issue of children. Okay, so again, if you have clients who have young children, then helping them realize what's the problem if they don't write their will, what happens to their kids, the potential consequences that will befall them, then that's again something that should be close to their heart. Okay, so we're going to go into these 3 scenarios, but maybe a good time to ask, right? What other problematic assets that the client have, or situations that the client may face beyond these 3? For those of you who can recall your IBF 3-day workshop, Wills and Trust workshop. What other assets are problematic? Sorry? Equities, okay, and why is it problematic? Answer is correct, but why? Okay. It could be a not quite there, right? It is a problem, but not in the way you highlighted, because at the end of the day, okay. Correct. Okay. So if my client tells me I have no US equities, so no problem. But I have I buy Singapore securities only. I have unit trust. So is that a problem? Yeah. So the point here is that for investments, there's an example of a problematic asset because it does take some skill to manage it. So the person that owns it right now, the testator, probably dabbles a little bit. He probably knows a bit more about it and handles investment. But again, if he doesn't deal with it adequately and he relies on the residuary estate to distribute it, then it goes potentially to, for example, again, my simple example I always give, 50 to spouse, 25 to son, 25 to daughter, right? If the spouse is not financially savvy and doesn't know how to manage investments and the kids are both minor, then giving the investment accounts to that kind of beneficiaries may not make a lot of sense. So that's an example of a problem. So again, if you know that the client has investment accounts, because you're the financial advisor rep that sold the investments to them, right? And the client's surviving spouse and kids are too young to manage it, don't have the skill to manage it, then that's something you want to raise, right? Bring it up as a relevant point. And that's what I mean by contextualizing this see the need part to your client's specific scenario, right? Think through all the other assets. Overseas assets are a problem. If you have a business, that's a problem. If you have private property, that's also a problem. So these are some common types of issues. So let's go into each of these to highlight to understand where the issues are. Okay. So if they don't have a will, then these are the potential issues they face, right? Firstly, the lack of discretion. So explain to them about the ISA, the Intestate Succession Act. Again, we're assuming that they are non-Muslims. If they're Muslims, then they also have very little discretion. So for them, the issue of the intestacy, the lack of discretion, is where it's a potential problem. They don't have control. It goes to whoever they receive the assets. We're going to see some scenarios of that, so you could highlight to them. Again, the more you know about the family circumstances, that's where you can highlight the issues to them, right? So the second part is admin challenges. There's a need for more than one administrator. When the estate is at higher risk, right, the courts may impose the need for at least 2 administrators. On top of that, they may impose the need for sureties as well. Okay. Can you all remember what is the issue of sureties? Okay. Yes, that's one of the criteria. But what's the problem? How would you explain to the client, right? What's the issue of sureties? Availability of sureties. Okay. But what's the surety first? For the minor. Okay. It's not very convincing to me right now as a client. What would you say to the client? Why is it a problem? I'm getting you to think a little bit because we'll be practicing a little later. But why is a surety a problem? What would you say to them? Okay. So firstly, explain, right? If your estate has certain elevated risks, an example that Mei Jing, right? Remember? Okay. It gave was if your estate is worth more than $5 million, if you have children in your estate, by the way, this part you do need to memorize to do this well, right? And this goes back to your training materials, again, provided by Precepts. So there's a slide that highlights this list of scenarios here. So you do need to memorize some of this content to be able to articulate it clearly to your client. So elevated risk means if you have minor children, estate is more than $5 million, you have potential life interest beneficiary to your estate, you have potential creditors to your estate, the courts will typically impose the need for 2 administrators and 2 sureties, right? The job of the sureties is to pay back any losses that may be incurred because now you have these administrators that are appointed by the courts. They are typically family members who step forward and say, hey, let me handle all these monies. So literally everything is under their control. But because they're not professionals, right, things can go wrong. And so a vulnerable beneficiary like a MI, mentally incapacitated beneficiary, or children, they may not know what's their rightful share. They could not get the full amount. And so to protect their interest, the courts will impose this surety. Right? So these sureties will have to be as rich as you, right? Because they need to potentially pay back 100% of whatever is lost. Right? And these sureties typically are not beneficiaries as well, right, of your estate, because it wouldn't make sense for them to pay back the monies to the estate so that they can get their share, right? Because at the end of the day, it's still their money, right? So the question here is that as a client, do you have 2 friends who are as rich as you, who are willing to pay back any losses that your administrators may lose? Do you have such good friends? Then, of course, you wait a little bit and see what they say, right? Of course, nobody has such good friends, right? The reality is, who are you going to find? Where are you going to find such people, right? Who are willing to do all this for you, and they have nothing to gain whatsoever. They have everything to lose and nothing to gain, right? And so that's the problem with sureties. So you need to be able to, I guess, practice a little bit to be able to articulate these points, the key essence of what a surety is, maybe a simplified version. I went through almost a lot of the training material in the slides, but you may need to figure out what you want to say. But end of the day is to help them recognize that if for their estate, if they have a slightly elevated risk, right, in those situations, the courts typically impose sureties. Right? And that's really hard to find. If you don't get the sureties, you cannot distribute the assets at all. You get stuck at that point in time and nothing gets distributed. And that's a real problem. Right? So that's the admin challenges. And the last part here is document complexity. One of the problems is that once you pass away, right, you will have to prove that you are that level of relative, whether it's a uncle or auntie or a sibling or whatever, by providing the necessary documentation. Okay, so imagine if you're claiming as an uncle or auntie, how do you prove that you're the uncle or auntie of that person that died? Oh, how would you? What documents you need to show to prove that you're related to that party? You also don't know, right? That's the problem. You may need birth certificate, marriage certificate to show the linkages across there. Can you find that paper trail to reach, to show that you are related to the party? Really hard, right? Especially if you are a bit on, if the client in question, the person that passed away, is a bit on the older, 60, 70, 80 years old. You may need to go up to their parents' level, show marriage certificate, birth certificate, then come back down to show your siblings or uncles. Can you find that paper trail? Cannot means you cannot claim because you can't prove the relationship that you have to those deceased parties, right? But the good news is all this problem goes away through a very simple mechanism. And the mechanism is called writing a will. And that's one of the ways you can kind of conclude this whole discussion, right? So this is highlighting the potential problems they have, right? Other ways to tackle this is to give them a couple of scenarios, right? And this is an example to highlight where if you rely on intestacy, things can go wrong. I usually refer to this as the law of unintended consequences. At least that's the term I use, right? People don't intend for this to happen, but it happens anyway because of certain sequence of events which are out of your control. So let's look at this case. We have Peter here who has $2 million of assets and he's married to this lady called Jade. Okay, and these are some of the family members they have. On Peter's side of the family, he has his parents, and on Jane's side of the family, only Jane's mom is around. But unfortunately for Peter, he died. And so how will his assets be distributed via intestacy? As estate planning professionals, you should know this, right? 50 to? Yeah, so it's 50 to spouse, 50 to parents, because no kids at this point in time, right? So that's what happens, right? So the assets go 1 million to Jane and $500,000 each to both parents, right? Unfortunately, subsequently, Jane also died after that, right? Because it was a common disaster, just that Jane happened to die a little later, 10 minutes, 1 day later, but Jane subsequently died. So what happened to Jane's assets now? Goes to, via intestacy, it goes to Jane's mom, right? So if you were Peter's parents, how would you feel? Okay, I only lose half the assets, not so bad. Only $1 million, right? Would you feel that way? Of course not, right? It's your son's assets, but because of this sequence of death, the son happened to die first. Shortly after that, a day later, 2 days later, the wife passed away. Half the assets end up being transferred via intestacy to the wife's estate or the late wife's estate, and then the asset gets transferred to the parents because those are the surviving beneficiaries, right? Seems really unfair, but the question is, can you control when you die? You can't. And so because of this sequence of events which you have no control over, potentially half of your estate ends up with some other parties, right? And so that's an example of unintended consequences. I don't intend for that. I mean, if I were to plan, who do you think Peter would want to give his assets to if his wife is not around? Most likely his parents, right? I mean, given this limited scenario, most likely to give to his parents, right? Would he want to give to his in-laws? Probably not, right? It's my assets. My parents look after me. I will probably want to give back to them if I have no other immediate family members to provide for, isn't it? If my wife passed away shortly after that, no point giving to her. Okay? And so that's the issue over here, right? So let's look at a similar case, but now let's introduce one more beneficiary into the equation, right? So now we have a son, Paul, born to Peter and Jane. And again, same thing, let's assume Peter died first. Okay, so where does his asset get distributed to? Again, all these people have no wills. So it goes to spouse and kids, right? 50-50 each. So 50 goes that way. But unfortunately, again, because it was a car accident, they all died in this order of sequence, right? Paul died next. So what happened to the $1 million that goes to him? He's a kid, so he can't write a will. So it's via intestacy, it goes to parents, right? And so everything goes to Jane. but then Jane also died. So now what happens? Now everything that Peter owned ends up with Jane's parents. Right? Again, you can see the problem with that. And his parents get nothing. So obviously this is feels almost unreal, but it actually can happen, right? Through a sequence of death. And there's so many other scenarios you can think about. This is just very customized to hide the problem, right? But the reality is that, do we know who's going to die first, who's going to die last? We don't. In a common disaster, it's hard to anticipate the sequence of death. Just you can't sit in the right position to die last or die first or whatever, right? You have no control over that. And because of the intestacy laws, it ends up distributing that way, and it's potentially far from ideal. Okay. So in summary, by having a will, you solve some of these problems, right? Firstly, with a will, you avoid the need of sureties. The sureties come into play because it is the courts that appoint the administrator to look after the estate. But if you wrote your will and you pick your own executors, this problem completely goes away. There's no need for sureties. You don't find that. You decide on your executors to handle your estate, so this problem goes away. Next, you control your distribution, right? You don't rely on this sequence of events. You can say, if a certain beneficiary predeceases me, then don't give to that person, instead give to my substitutes. So you have a lot more control over your distributions, and it's not left to this default will that really doesn't fit anybody. Okay, you get to decide who your beneficiaries are. If you have a parent that has checked out of your life very early, just because that person is your parent, via intestacy, that person will still receive, right? But you may not want to give it to that father or mother who checked out of your life very early. You may want to give to the parent that's stuck around. So writing a will is a much better way to decide who your beneficiaries are. And finally, you can decide your appointment holders, right? You can decide who to handle your estate, who to look after your kids. You make that decision. If you don't have a will, you have given up the right to make this decision, right? So these are all the benefits of having a will, right? So this is one. I hesitate to use the word script, but this is one sequence of conversations that you can have for the clients to help them realize they have a will, right? So if you go back a little bit, okay, maybe not. Anyway, you all take pictures, right? So okay, just go through that again. Internalize what you want to say to the clients about the need of the problems of having no wills and the benefits of having a will. Okay. So that's scenario one. If you have no will, those are the problems, and that's an opening conversation you can have the clients to help them realize they have a problem. Okay. The next part here is to talk about dealing with a HDB flat. Okay, we're going to again, if your client has a HDB flat, you can ask them in that initial conversations, do you have a HDB flat? If you have, great. And again, since like 80–90% of people in Singapore stay in HDB flat, chances are most of your clients would have this problem as well, with distributing HDB. Okay. So the first problem here is about the property ownership, right? One of the problems with dealing with HDB as part of your estate plans is it's really hard to give it away because of all the ownership restrictions, right? And so you should know what some of these ownership restrictions are, right? These are the details that you have to know. Again, all these details are found in the slide. They are not meant to be comprehensive, but can you remember some of the key ownership restrictions with regards to HDB? What are they? What about private? Okay, if you are single, you may not be able to own a HDB. You're not eligible to own a HDB. So that's one. What else? Yeah, your nationality applies, matters, right? So who can be eligible to own a HDB? Singapore citizen or a PR, right? If you're not, then you can't either. Okay, that's another scenario. What other ownership restrictions are there? Huh? So under the orphan scheme, if you want to own a flat, you must one of the family unit definitions, right, is to say the parent. Okay, so there are a couple of these things. So you do need to read some of these details to be familiar. And the problem is that it's very hard to anticipate the scenarios of your beneficiaries at that point in time, right? Especially if you have surviving spouse and or kids. It's hard to anticipate what scenario they will have So giving HDB is particularly problematic. Okay. So we see that there are citizenship restrictions, there are single scheme. If you are single, you have to be above 35 to be able to own. In terms of marital status, you need to be above 21 before you can own HDB. In fact, in Singapore, you need to be above 21 to own any kind of real estate, okay, whether it's private or HDB. If you're above 21, then you need to be either a family unit, which means you have to be either married, widowed, or orphaned to be able to own a HDB. Okay. And these rules may or may not change over time, so we do need to keep abreast. So because of all these ownership restrictions, it's very hard for us to simply say, when I die, give my HDB flat to all my kids, right? Because if some of them can't own, then you are faced with a lot of complexity over there. So let's look through 4 scenarios. Again, it's not meant to be an exhaustive list, but to, again, help you all think through some of these issues. The potential problems over here, right? So let's talk about the first scenario where we have a typical family, common disaster happens. Husband and wife who are joint owners of the property, they have 2 kids and they pass away. What happens to the property? What do you think the parents would like to do with the property? So the yellow one, common disaster scenario. They would like to keep the house for the kids, isn't it? Question is, can or not? Can I write in my will, I want to give my house to my kids when I die? Okay, so let's talk through a couple of variants of that, right? Let's say the kids are 8 and 11. Can they inherit the flat? No? So if not, where will they stay? They may have to stay with the guardians, right? Or somebody to look after them. So chances are they can't stay on their own. And so if you cannot stay in a flat over there, do you think HDB allows you to keep the flat for them? Probably not. Okay. So let's make the scenario a little bit easier. Let's say they are older. They are 18 and 20. They should be able to live on their own independently. Can I keep the flat for them? Again, we saw the ownership restrictions earlier, right? You need to be 21 before you can own. So chances are you again can't give to them, right? Because they are underage. And so we also know that HDB cannot be held in trust, at least not without HDB's explicit permission. So that's part of the problem with HDB, right? And so when you think about HDB, there are these 2 scenarios or 2 stages of the planning, if I may use that word, to keep in mind. So when we are talking to clients about this potential problem, we are in the pre-planning stage. They're not dead yet. They're still alive, right? And so in that situation, there's the default rules for HDB are very restrictive in terms of what you can or cannot do with the HDB. So if you write in your will, I want to hold this HDB in trust for my kids, it merely becomes a wish, and we have no guarantees that the flat can be held in trust for them, right? We can put that in a will, it's possible, right? The client will have to pay for it, for that clause, the testamentary trust, but there's no guarantees that the flat will be held in trust for them. Okay? And that's the problem with the pre-planning. Okay? There's something you need to surface to the client because of all the ownership restrictions. And HDB typically will not give you this advance permission, right? As I said, it can be held in trust. And this maybe goes to the second part of the planning I was talking. If you're doing pre-planning, it's very difficult. But if the client has already passed away, HDB can be very, very compassionate, right? If you don't quite meet the original criteria, they can sometimes bend forward. In fact, I just went to the website earlier to look at this, and I found this part on the website where they say, these are criteria, but if you need some help, you can always reach out to them, send your scenario to them, and they will consider. So this is the 2 stages I was talking about, right? First stage is you're doing pre-planning, writing the will. You can put all these instructions. I want to hold this property in trust for my kid, everything, but it nearly becomes a wish and there's no certainty it can happen. But if the client has already passed away, then the way we advise them or deal with them is a bit different. You can please ask them to approach HDB, right? Can approach HDB and says, can I have this flat held in trust for my kids? Even if they are 18 and 20, for example, right? HDB can be compassionate. They may work out some things to have somebody hold the flat in trust for them because chances are they're going to be old enough to be able to stay there on their own. Soon maybe just don't quite meet the original criteria for the orphan scheme or whatever other scheme. And so HDB can be compassionate and bend their rules to meet the circumstances, right? So depending on the kind of clients you're talking with, if you're doing the wills pre-planning stage, then it's very restrictive. But if the client has already passed on, then by all means, please reach out to HDB. They can be very compassionate, okay? So coming back to the common disaster, right? So the kids typically end up staying with their guardians, right? If you did a will, then hopefully you appointed a guardian, so they stay with the guardian. And so if they can't hold the flat for them, you probably can't hold it in trust. Even if you request for the flat to be held in trust, if they're not staying inside there, chances are HDB will say, you're not staying there, you're not going to be staying there for the next 10, 8 years, 9 years. So no, we don't allow you to have it held in trust for the kids. So you have to sell. Okay? So that's the common disaster scenario. And so you need to be able to have that, to be aware and have that conversation with the client to help them realize, oh, okay, HDB is problematic. And if I'm in this scenario, husband and wife, 2 kids, which is quite common, it's a problem. Okay, let's move on to the next one. Transnationality families. So that's the scenario where I have one spouse that's Singaporean and buys the flat under the foreign spouse scheme. And then the spouse is a foreigner, not Singaporean, not PR, foreigner. Right? And so the scenario is this, right? If the current owner of the flat dies, what happens to the family? Yes, oops, that's a very big oops. Okay, so what happened to the family? Can the husband say, well, let's assume it's husband, right? It seems to be more common that way, although I skewed more towards guys marrying foreign spouse, foreign wives. Okay. By the way, I looked at some stats. It's about 11% of the population fits, based on 2024 statistics, right? There's 176,000 families that are in this scenario. One spouse is Singaporean, owns the flat. The other spouse is a foreigner. 176,000 families that way, about 11% of the population. 11% of families. Okay, so it's a pretty big issue. So how do we help this? How do we help these clients in this case? What are the options we have for them? Can I just write my will when I die, give my flat to my wife? Cannot, right? Again, we saw the HDB restrictions, right? In those situations, one possibility is if it really happens, you can appeal, right, to HDB. So HDB will evaluate the situation and they may allow the flat to be for the family to stay, especially if one of the children, if the children are Singaporeans, they may allow it, right? But from a planning perspective, the answer is no, we can't give it to the spouse, right? Because spouse is foreigner, not Singaporean, not PR, so cannot own. So how do we help them? How do we help them solve this problem? Yes, that's actually a very solution, right? Because for many people, estate planning is the last thing on their mind. Most of them are thinking about their next holiday, looking at whether COE go down, can buy the car or not, thinking about what they want to have for the weekend meals, but they never think about these kind of urgent issues, right? If you have this conversation with this kind of families, they suddenly realize, hey, I thought I just wrote a will, give to my spouse, everything is settled, but it's not settled, right? Because that gift may or may not take place, and there's a lot of uncertainty over there, right? So when they realize this, having this conversation, it may prompt them to start taking the application for PRship or citizenship a little bit more urgently, and they can maybe expedite their case. So that's one possibility, right? But that doesn't solve the problem immediately, because in any estate plan, the basic assumption is the owner of the flat dies today or tomorrow. The plan must work at that point in time, right? So applying for citizenship, it's a good start, but not enough. So how else can we help them? In this kind of scenario, there's always 3 solutions, right? Wills, trust, or insurance. Which one will work for them? Insurance too? Buy a house. What kind of house? Yeah, it may be possible for them to buy a private property, right? A foreigner can own a private property. or at least a condo. They can't buy landed property, but they can buy some airspace in Singapore, right? Strata titled property. So that's a possibility. So one way is to provide funds for them to acquire a private property. So that's one solution. Okay, what other solutions? So rental is another possibility, at least a short-term solution. Okay. If they can't, they can rent, right? They could stay with family members. Okay. So these are some possibilities. And I guess the key thing about estate planning is that there's no one perfect solution for everybody. Everybody's scenario is a bit unique. So what we're trying to do really as estate planners is to help the clients realize, hey, these are the different options. Each of these options have certain set of advantages, certain sets of disadvantages. Which set of these are you willing to accept? For most clients, they're very limited in terms of what they know can be done. Right? For them, for example, I just write a will, give to my spouse, and that's it. That's all I know. Right? They don't realize there are other things we can do. So we as estate planners have this advantage of learning about it in a class like that, reading about case studies and dealing with other clients. And so we have more solutions in our toolkit to give them different options. Now, each of these options always have pros and cons, right? Buy a condo, great, but takes a lot more money, right? But is there enough money? Am I insurable? Maybe the spouse is not insurable, then maybe that's not an option. Okay, rental might be a possibility. Depending on the age of the kids, maybe the kids can buy a property subsequently. So there are many different variations. And so look at the client scenario and figure out what are the possibilities and discuss the pros and cons with them, right? So that's for transnational families. Next one, scenario. I have a single parent, and in this case, sole parent own a property, and I have 4 kids. And the plan is when I die, I want to benefit all my kids equally. Is that a good idea? Each of them get 25% share of the flat. Not a good idea. Why is that not a good idea? Yeah, each of them may have their own unique circumstances that they're facing, and if they all can agree and all have an equal share in the property, you end up pitting them against each other, right? To try and get everybody to agree becomes a problem. And so imagine this scenario, right? We have 4 kids. First kid on a BTO queue, waiting for the flat. Just got married, waiting for the flat. Second kid already owns a HDB flat. Third kid owns a private property. Fourth kid doesn't own anything but stays in the flat with the let's say the dad. Okay, so when the dad dies and he gives equally to all the kids, what happens to the kid with the BTO? Can they inherit the 25% share of the flat? Cannot, right? Because they end up, if they become owner of the flat, then they cannot be in the BTO queue anymore, so they lose their house. So which one do you think they would prefer? Quarter flat or their own flat? No brainer, isn't it? So what are they going to do with the quarter flat that they receive from the dad? Sell? Sell to who? Okay, you'll think of a solution. It's a sell to the 4th one possibility, right? Let's hold the solution first. Let's look at second child. Second child has a HDB flat. Can they receive the quarter flat from the dad? Also cannot, right? You can only own one HDB flat. You can't own more than one. So again, cannot own, have to sell. Then sell to who? Same problem with hold that as well. Child number 3 owns private property. Can receive flat or not? There are a couple of criteria over here. One of them is to first check when the flat was first purchased. Depending on when it happens, if it's a more recent purchase, I think before 2010, if I recall correctly, then the answer is no, cannot. If it's after 2010, the answer is cannot. You cannot have private property and HDB at the same time. So again, have to sell. If it's before 2010, you must have finished the minimum occupation period, or rather the family will have to move in, stay there for the minimum occupation period of typically 5 years, and then they can own. Now, if you stay in a condo, would you want to move into a quarter flat and stay there for the next 5 years to own that flat? Probably not, right? So again, cannot own. So sell. Then sell to who? Sell to the last child. So that seems like a perfect solution, right? So but that's a big assumption, right? Because in order to close this case or finish up properly, we have to assume that the last child firstly has money to buy over from the sibling share, right? Second important assumption, if he has the money, which is really a big assumption. Second assumption we need to also have is he's willing to do it, right? And these two are very hard to maybe align properly, right? It may not happen, right? And on top of that, if all these lines up, the child that buys over the 3/4 flat from his other siblings ends up having to pay stamp duties on the 3/3 that he buys over, because the distribution doesn't follow the will anymore. And so even they agree. Yeah, so may not be able to even own a flat. So there are all these, yeah, the whole ownership restrictions potentially apply, right? It doesn't qualify under the single scheme and things like that. May not be able to own it as well. Okay, so you can see that's also problematic. So what can we do in this case? Self-insurance, okay. Can you elaborate? It could be the answer, it could be. I'm not saying no, it's usually the answer. Okay, so you're talking about estate equalization. Is that what you mean? Okay, so one possibility is the father looks at the situation and says, oh, I got 2 kids with potential HDB, 1 kid with condo. Maybe I give the kid the whole property to that one child who doesn't own the HDB so he can continue to stay there. And then I give something else of equal value, right? And we call that estate equalization. You don't have other things of equal value, then you create something of value through insurance. Okay, but depending on how old the father is and whether insurability is there, yeah. So anyway, that's one possibility. Okay, worst case is potentially sell the flat and distribute the cash, right? Then the poor kid who's staying there may have to stay at a sibling or whatever else, rent or whatever. Okay, so again, no perfect solution, right? You really have to look at the individual circumstances, have a dialogue with the client to understand it's complicated. Typically, it's as fast as possible. Rough guideline, HDB gives you about 6 months to deal with things, but they can be compassionate to, as long as you're demonstrating that you're trying to sell, but you still can't sell, they can extend. Okay, so it's not a hard deadline. Okay, the last scenario you want to consider would be if you have a single staying in a flat, right, leaving behind, say, parents and siblings, then the single passes away. What to do with the flat? Okay, what can we do? Maybe this is a bit easier. Right? If the single wrote a simple will, right, give 50 to parents, 50 to siblings, then the flat gets distributed that way, right, which is not ideal, because if they all have their own flat and stuff, then it becomes a problem. So in this case, a better solution was simply to sell the flat and give the cash. Okay, so that's a simple solution. So I'm using these 4 scenarios to just help you think through all these different problems, right? And what you're trying to do in this case is, when you're talking to the client, understand a little bit more about their family circumstances, who are they, who are the potential beneficiaries, and highlight to them why it's a problem for them. It's always going to be a problem, almost every situation, right? It's just helping them to realize it's a problem, and then have the dialogue with the client, right, to help them realize what are the different options you have, right? Is selling the property an option, giving to one party an option, do estate equalization, upgrading to a condo if it's a possibility, sell the flat, upgrade to a condo or whatever else. So you have these different possibilities through these scenarios here, and then you share that with the client, talk with them, different options, pros and cons, and that's what you're trying to do, okay? Okay, I think we've been spending a bit more time on that. Yeah, why don't we take a short break over here for maybe 10 minutes? Yeah, we come back at 3:36 and then we'll resume our class. If it's part of the estate, yes. That means it's not nominated. Because then it'll be part of the estate. If it's nominated, it bypasses the will, so not part of the estate. It's any of those conditions. That means 5 million, or if there's children. So usually I will highlight the issue of children, right? Because chances are you have kids. As a minor, they don't know how to look after their own interests. So the courts have to provide extra protection for them. So that's why they will. So the wife, okay, so when you say kids, right, an example of complexity is you have kids from different marriages. So you have the current spouse who says, I want to be administrator, but the ex-spouse will say, I have kids. Now I want this current spouse to make sure that my kids get the rightful share. She may object and says, no, really. Because it becomes, the courts have to pick somebody to handle the estate. Then the courts feel that there's a need for surety because there's some elevated risk, right? Then they will impose surety. That's considered as elevated risk. So because a lot of money, the risk here is there's a lot of money, so a lot of things a lot of losses can happen. I didn't talk about that. Actually, was it in the slide? I can't remember. I think under the admin challenges. So you're right. Part of the process I didn't highlight it here, but it's again in the notes, the precepts notes. So you need all the default beneficiaries tend to follow the intestacy law because the higher priority ones have the most to gain. So if the administrator wants to handle the estate is lower in priority or not even in the list, let's say a friend, for example, right? All the other beneficiaries over there will have to sign this renunciation of rights to give up their right to be administrator, to allow this lower priority beneficiary or this lower priority administrator or not even on the list to act. So you need the consent of everybody, and that's how they give their consent, by giving up their rights to be administrator. The lawyers are typically engaged by the family members to guide them through all this paperwork and what form to sign and everything, because most people have no idea what happens. So the lawyers will be the one that will say, hey, you need to sign all these things. Who are the potential beneficiaries? Do these people exist? Then you need to go and gather all these people, sign the renunciation of right forms. It depends on when it happens. So if before the estate is distributed and another one died, assets distributed already, finished, or okay. So it depends on whether the deceased sibling has children. Under the intestacy laws, if they have children, the children will receive the share that goes to the deceased sibling. So this one that died already, right? If this one has kids, so if this one that died, right? But this one has family, not has children, so it's okay. So the share will still go to that. It still count as 6 shares. The children will receive the share for the deceased sibling. That's what the ISA says. Yeah, so that's the problem. Trying to get everybody to agree, sign the paperwork. Then you need this because the family members, some other parties want to be the administrator. You didn't choose, right? And so as part of the safeguards, the courts this is the court process. For your letter administration process, if you want to pick this administrator, you need to go through this paperwork for all the other parties to give up their rights to allow somebody else to act. So only the party who wants to act will not sign the form. So then they will say, I'll be the one, I got all these paperwork to show, everybody else agree for me to be the administrator. Doesn't go to the government. So they have claim under intestacy, and then they got to provide paperwork, show that they're related to the person, birth cert, everything. It's the administrator that will have to go and find them, or assuming that if they can't even get those people to sign the consent, then you get stuck. So in those kind of situations, right, the reason the court imposed all these safeguards is because it's lay people doing all this work. So one way around it, again, this is in the notes. One way around this is to appoint a professional to handle this, a corporate trustee or corporate administrator in this case. Because for them, they have all the checks and balances, the audit trails, they know what to do. So the courts will not impose the need for these sureties and everything on a professional. Yeah. So yeah, so these are where potential delays can happen. They can still try appeal to the court and then see whether they can still proceed or not. Yeah. Because if you can't find them, typically you need 7 years to deem them as dead before you can carry on. Yeah. Potentially at least 7 years. So for this part of the planning is as part of estate planning, right? We look at all his assets, but since he has business, we have to do this form called called business succession planning for him. Simple starting point. So, Mr. Testator, when you die, what do you want to do with your business? And then let's see what he says. Typically, there are only 3 options. He either gives it to some family member to take over and run, he sells it away, or he just winds it up. Of course, there's a lot more things to discuss at each of these different options, except for the winding up. Giving away is difficult. There are many different options. Like give to who? Who wants the business? Who? Again, if you don't plan and just do a simple will, right, then it ends up being split to his residuary beneficiaries, which may not be ideal because they have no idea how to run a business. Then it defaults to the wind up the business because it just dies naturally. So that's not ideal. What's the purpose of the UL in the first place? Is it keyman insurance? Is it for his family? So you got to understand what the policy is for. I mean, somebody may should sell it and he doesn't know what it's for. So succession planning is a bit more complicated because there are many different, it depends on how complicated this depends on the nature of the business and how is it structured. For example, he's the main guy running it. Then if he dies, then the whole business may actually just die with him. But the problem then becomes all the effort and time he's building the business, his family doesn't benefit from it. So that's not ideal. So if it's a Chinese national, then you probably need to at least understand Chinese distribution laws. I don't know what are China's distribution laws. So that has to be part of the planning to consider, right? But that's important as part of the overall plans in terms of knowing what you can or cannot do. But the succession planning part still applies, right? Because it comes back to what does he want to do first, and then figure out what's the best way to achieve that, right? Then it's a matter of, should I do a Singapore will and or a China will, or maybe just China will to do with the China assets or whatever. So if the business is all China based, then probably doing a China estate plan will and or trust or whatever probably makes more sense.
Yeah, so actually, I want to just more saying that don't have any real trust in because the trust company in China they are just established recently, like not recently, that don't have like a long track record. So that's why he said the trust company cannot be trusted. Yeah.
Possibility. Again, and it goes back to different regions have different level of maturity as well. So it depends on where they are from as well, where the companies are established. Other thing you want to check is whether can, let's say a trust company in Singapore hold those shares. I don't know what the local laws over there. Can a foreign entity hold shares? And so that these are things to check out. There's a lot of research to be done. That one you can attend a course by Cindy. She'll talk about their strategy. So that's usually the starting point for estate planning conversation for China. How do I move money out? Yeah.
This. You want to get anything for you?
Yeah, I need some water, I think. So I need that's good. Okay. How is the property owned currently? Is it a joint tenancy? So yeah, in this case, if it's a joint tenancy, then the part their will is a contingency plan where they are the last owner. So she passes away first, everything goes to the husband. She can, but it's not pleasant, which is to sever the joint tenancy and then she owns 50% of the property. But doing that will cause problems for the marriage in the first place, I suspect. Yes. And she can do that without the consent of the other party. Each owner can always unilaterally sever the joint tenancy and it becomes a 50-50 arrangement. Do that on her own. Yeah, but as I said, if she does that, right, it will cause other problems. Yeah. So typically you take that step more as the marriage is really yeah. Yeah. Because the other party can always change the will subsequently. So I mean, I've written 60-40 right now, but after you pass away, I could change my will. Yes. So there's no there's no way to stop that. And that's actually one of the reasons why sure. But same problem again after that, right? If they buy the HDB, then the HDB still has a problem. So what form of ownership? Should it be joint or should it be tenancy in common? Because if you go around the tenancy in common route, it seems like they're not trusting each other, and that could start off the problem in the first place. And there's no problem, you stir it out, then suddenly it's a problem. So it's not easy to handle that. Some level of trust is required. There are other ways around that, but they are not pleasant still. You can do, for example, a family deed, basically like a contract between family members to agree on doing certain things. But again, the enforceability is also an issue. Yeah. Yeah. So that property, that joint property, probably be hard to deal with. You just look at other things you can deal with. Okay, I think let's resume our class. Again, due to time constraints, we're going to move on. I'm going to move through very quickly for the next part of the slides on guardianship. So the last part is on children. And I'm going to go through this in 1 or 2 minutes very quickly. This is just to show you these are some real things that can happen, right? It's to help them realize that if they don't plan for their kids by writing a will and naming a testamentary guardian, then potentially things can go wrong. Now, I'll be repeating this part a little bit later, so I'm going to skip through quite quickly here. But this is to, again, highlight the different points of conversation with the client to help them realize what they need to plan for. So surviving parent will always be the guardian of the kids. You can't extinguish the rights of the surviving guardian. The only thing you can do is by writing a will, you can name a testamentary guardian. Okay? And the scenario that you're typically looking at is these two scenarios. Should the guardian act jointly with the surviving guardian, with the surviving spouse, or should the guardian only step in when both parents are not around? So typically, if they're happily married, then chances are you're looking at the scenario where when both are not around, then the guardian steps in. If they're divorced, then this is where you're probably looking at, I may want to have the option to pick somebody to represent my interest in the kids so that the surviving spouse, maybe he or she has remarried, doesn't have the only say in terms of looking after the kids. The person I appointed as my testamentary guardian, as my representative to look after my kids, has a say in terms of what happens to the children as well. So that's where the testamentary guardian part comes in. And how you convince them is because of the last point over here, right? Which is if they don't write a will, they gave up their right to name this testamentary guardian to step in either of these scenarios, and then it becomes the courts that will be the one that will pick the guardian. And in the worst case, the guardianship may end up with a foster family, right? And that's far from ideal. So parents should always exercise their right, if they care about their kids, to plan for that, to pick this guardian. Okay, so this part, to demonstrate your expertise in this area is where you can explain to them about what is the responsibilities of the guardian. So custody is they look after the kids, support is to provide maintenance, feed the child, clothe the child, make decisions on education and medical expenses, medical decisions. So these are all the things that the guardian needs to do, right? So that's what we talk about, and help them to realize who in their circle of family members would be in the best position to do this for the kids. Okay? Then the next part here is to think about another question when it comes to the children is to who looks after the money, right? Guardianship looks after the children, who looks after the money? And so it's whether the guardian and trustee should be the same person. If you recall the notes we covered in the wills part of the training is that either way has a problem, right? If you park the guardian and trustee together, it can also be a problem because then there's very little check and balances, right? Guardian looks after the kids, also have access to the money. It's easier for the guardian to manage it, of course, but the trade-off is guardian, if they don't track the monies well, then by the time the kid is old enough to receive the inheritance, there may not be an inheritance left, right? On the other hand, if you impose more checks and balances, you split the role of guardian and trustee to be separate parties, then it can be very onerous on the guardian to do the work. Every time they need money, you got to ask the trustee. Trustee's job is to check, and so they will ask questions, right? Why you need so much money this month? I thought I just gave you money for the notebook. How come the notebook spoil again? Please show me evidence and whatever other complicated problems. It becomes very troublesome for the guardian, and the guardian can simply say, you ask me all these checks. You look after the kid. I don't want to do it anymore, right? So it can be problematic. So where we demonstrate our expertise in this space is to have this conversation with the clients, right? Help them realize that this is something they need to think about, and it may not be so easy to just write somebody's name inside there, right? There's a lot of things to consider, and these are examples of things to consider. Okay. Now the last part over here, I'm just going to move through quite quickly. You can snap a picture and then you look at it at your own time. These are some of the common objections that client may have. I'm not rich enough to do estate planning, so I don't need to do it. Or my family is not like that. We all love each other, so I trust them. Okay. Yeah. So, or third case, I don't need don't I need a lawyer to do all this estate planning? How can I do that with you? You're not a lawyer, right? So you don't need a lawyer. You can actually write your own will, but that's probably a bad idea anyway. Okay. Then fourth case is my situation is not so difficult. I'm very straightforward. I'm not very rich. My family love each other, so a simple will is good enough, right? I always say simple will tends to lead to complicated estate planning problems. So we'll talk about how to tackle this next. And the last part here is I can do the planning myself. I don't need a professional. DIY, right? So how do we tackle all this? This is the way we tackle it. Help them recognize that by having a will, even though it's simple, they're always better off having a will because it makes things faster and cheaper for them to distribute the estate than not to have a will, right? The whole issue of sureties and guarantors, the need for two administrators, the renunciation of rights, all that comes into play. Why it's faster. Then most of the estate planning fights are between family members, right? So for the family, if they realize that it's always between family members, right? Show them a couple of case studies that you can grab from Twinkle and to show that it's always families that fight, right? If you do the informal method of, I everything give to my oldest son and he knows what to do, this is where all the fights happen. Okay. So for a lawyer, they help them recognize they don't need a lawyer to draft the wills. They can do it themselves. But again, if they do pick somebody, you want to pick somebody that's competent, who knows how to do estate planning, because lawyers who don't actively practice, if they are mainly doing conveyancing, then they may not be in the right position to handle some of these matters. Okay. In terms of doing a simple will, right, as I said, most clients don't know what they don't know, right? And by having that conversation about talking to them about their HDB flat, helping to recognize that if they have kids, they don't have a guardian, it can cause all kinds of issues. Help them realize that it is not something that they are aware of and they need some help to handle that, which also tackles the last part, which is why they need a professional to help them get their work done. Okay, okay, so in summary, before we move on to this next part, in the pre-sales conversation, there are 4 things we need to do, right? The first part is positioning yourself. You're not just an insurance salesman, you're not just an investment salesperson, you are a comprehensive financial planner, right? And it covers your budgeting, your protection, your investments, as well as your estate planning. So we want to position ourselves as that. Second thing is to help the client recognize they have a problem, right? Pick any of those assets that you have. Pick one that is very relevant to the client. The more you know about them, pick one that's relevant to them, so it becomes a lot more personal, right? Examples I gave here is if you don't know the client so much yet, or that prospect, then pick one, right? Talk about intestacy problems, talk about HDB problems, talk about what will happen if you don't pick a guardian, right? The kid may end up in foster care. So use any of this because these are things that most people will face, they just don't realize they face it. So step number 2 is to help them recognize they have a problem. Step number 3 is when you highlight these problems as part of your conversation with them, you help them solve their problem. You are demonstrating to the client that you are the expert. You know what's going on. You know the typical solutions. You have that dialogue to talk that through. But at the same time, you don't know all the problems the client face, right? So you can't tell them, hey, look, I only know this one problem right now because I know your HDB flat. I don't know what other assets you have. I don't know who your other beneficiaries are. And I therefore don't know what other problems you face, right? If you find that this is valuable, then the next step is pay the deposit, sign the LOE, and you close the case at that point in time, right? So the workflow is help them realize they have a problem, help them realize that you are the solution to the problem, and therefore they should sign with you, right? And then if you meet objections, tackle the objections accordingly, right? So that's what we typically do in our opening conversations. And if done correctly, once you practice that, it becomes a bit smoother. If time permits, we'll try to practice that later. Then hopefully you close the case in the first meeting. Right? That's always the goal you work towards. Now we come to the main part of this session with the remaining hour plus is to draft an effective will. Okay, normally it takes me 3 hours to go through this, so we will try to get through this in an hour. Okay. Or actually less because we still got the role play. Okay, let's see. All right. So I started by talking about effective will, right? Many people think of simple wills, and the criteria I have in mind when I'm helping clients draft the will is these additional bits, right? We want to make sure there's sufficient redundancy. So by that I mean whenever we pick appointment holders, for example, we want to make sure that we don't just pick one executor, right? Many people when they write their will, they just say, pick my spouse to be my executor, and that's it. But they never consider what if a common disaster happens, and that's where you talk about contingencies, right? If a common disaster happens, both husband and wife pass away, then you just lost your beneficiary, lost your key appointment holder, right? So to plan to have sufficient redundancy means you don't just pick one executor, you pick a substitute as well, and consider having a final substitute for your corporate executor, right? In terms of contingencies, you plan for things like common disaster. What if a common disaster happens and your main beneficiary spouse passes away as well, together with you? Then who else are you giving your assets to? If your children also die together with you, the share that is supposed to go to the kids, who else should it go to? So you plan for contingencies that happen. And then the last part for a will to be effective, right, to actually deal with it adequately is to think about dealing with assets appropriately, right? So we saw some examples of that earlier, like HDB is problematic, property is problematic, overseas estate assets are problematic, businesses are problematic, investments are problematic, cryptocurrencies are problematic, and so many more, so many problems, right? Pick whichever one you want. The idea is that when you have the list of assets the client has, you look through this list and help them identify, okay, these are all the problems. These are the typical ways we deal with that. Which way works for you? And that's really what we're trying to do. Okay? So that's the idea of an effective will. Okay, I think at this point in time, maybe we can give out this framework. Okay, let me just split this. Okay. Just give it out as well. Okay, so for this workshop I run, I do have my own template, but we're going to try and maybe make use of this in some form to, okay, as I said, this is kind of work in progress and it's not exactly the right form we are supposed to be using, but we will make do with it. Short one, is there any more this side here? Okay. Actually, the parts that are relevant are found in your estate planning framework. So, yeah. So you can refer to this in the meantime. I think they're given out also, right? This one, Annabelle just gave me just now.
Oh, okay. Just three.
Okay. So in your mind, what I'm hoping that you all will do is as I said, this is not the actual form. It's still kind of in the works. But I think when you think about a will, this is what I hope you can imagine when we're talking about a will. There are these 5 key things I'm trying to do. Executor, guardian, okay? And these 2 are your appointments. Okay, if you look at your framework, I think they use a slightly different term. I think they call it position. See here. Now, if you look at the overview of your framework, they call this part 4 positions. I think it's also inside the printed copy, but you can refer to the estate planning framework. Those are your positions. Okay. I don't differentiate between the trustees role at this point in time. I just keep things simple. Executor and guardian. And so that's the appointments, right? Then the next part I'm interested in when I'm doing the fact find is to identify the three forms of distribution. I start off with residuary first. Okay. Then I talk about specific gift. And then finally, testamentary trust. Specific gift. Oh, this one? Yeah. Residuary. Sorry. I wanted to be a doctor last time, so I was practicing how to write like a doctor. Okay. So to me, when I'm doing a fact find, these are the 5 things I'm interested in, right? And I don't need to get all the details. There are a couple of key things I'm looking at. So in this part of the session, we're going to try and do this whole planning, right, for all of you all. So the forms are supposed to have this simplified version. Usually I give out I have this checklist, but Precepts is in the midst of creating a version of this. So yeah, it's kind of work in progress right now. Okay, so we start off with the idea of the executor and trustee. So in the fact find, what I'm trying to do is to help the clients identify who is the executor and trustee, right? If you do look at the form itself, it's pretty straightforward. We just name the parties, right? Going back to the principles of an effective will, we want to make sure that when we pick these appointment holders, there are sufficient redundancies, okay? So what I'm trying to do in this session is to help the clients recognize who is a suitable executor for the client, right? And the way I do that is I go through helping the client understand the responsibilities of the executor. Now, I don't go into a lot of details, but my objective here is to help them realize that, hey, it's a lot of work. That's the gist of what I'm trying to do, okay? Then I talk a little bit about selection criteria. What do I need to keep in mind in terms of the characteristics of the executor that will make a good executor? And then finally, some possible candidates. Right? Okay, this slide is not meant for you to take. I mean, you can take a picture, but it's something I ChatGPT'd out. So don't worry about it. Yeah. The purpose of this slide is to help the clients recognize that the responsibilities of the executor is a lot. There's a lot of things they need to do, and it's a lot of work. It takes a lot of time. Right at the end. Okay. So in terms of the handout, right, as we're going through this portion, you want to probably look at you didn't. There's some pages missing. I think it's double-sided. You need that one side, is it? So those who just got it, I think it's missing one side of the. It's supposed to be double-sided. I think that's the incomplete one. So you may. Okay, so in terms of this, for somebody who got the latest copy, can I just take a look? Okay, I think this is I'll just borrow this first. Still clean. Is that double-sided? Yeah. My objective when I highlight here is that, again, I'm not trying to steer the client towards picking a corporate executive because that's one of the options, right? I'm helping the client to understand what the executive needs to do. So you can, I mean, ChatGPT the same thing out, but there's a lot of work for the executive to do, right? To gather the assets, a more comprehensive and detailed version you can get from, again, the wills part of the course about the different roles, what they're supposed to do. At the end of the day, their job is essentially to apply for grant of probate. Once that's obtained, gather all the assets and begin the distribution. Seems like pretty straightforward until you actually have to do, then it's actually a lot of work, takes a lot of time, right? And the executor can also be sued. If they don't do a good job, they can be sued. There are case studies that highlighted that again, which I remember where this lady was executor and guardian for the estate, looking after one of the beneficiary was a child. the child grew up and sued the executor, because she didn't manage the money so well, was unable to account for some of the monies, and as a result, was liable for about $87,000, couldn't pay, and then became bankrupt. So imagine now you pick a friend or brother or sister who plays this role, then later became bankrupt as a result of that. And they don't get paid to do this, at least not by default, right? So it's a onerous role, it's heavy responsibilities, but it's also a very critical role, because if they don't do a good job, the family basically doesn't get access to the estate. Right? So this role is quite critical. So in terms of criteria, this is usually what I would highlight. I want to find an executor that is able to act, right? And the acronym I use over here is, firstly, they need to be available, because it takes a lot of time and effort, right? You have to deal with financial institutions, banks, insurance companies, you have to go to court, deal with lawyers, deal with various government agencies, CPF maybe. So there's a lot of entities and agencies to deal with. It takes a lot of time. You have to write into this organization. For example, if you want to just find out how much money somebody has in a bank account, as an executor, remember at this point in time, you are probably not recognized yet. You're starting to figure out what assets are there to submit the schedule of assets and liabilities, right? You write to the bank and says, I am appointed to be the executor, and I want to know how much money he has in the bank account. You think the bank will just review the money, review the information straight away? No, right? They will not. They have to check. And you write one time, 2 weeks later, nothing happens. And you write in again. Then they tell you, refer to this other department. Then you write to the other department. Then the department says, no, this is not the department that handled that. It's the other department. Then you write to the other department. Then the person says, oh, this person has already left the company. You can imagine all these things happening. And you do that for every different asset that the client has. And you can imagine how long it takes, right? If they are not on the ball, they just sit there, or just wait. Hopefully something can happen. A lot of delays can happen, right? A lot of problems can happen. So they need a lot of time to do that, follow up constantly, and that's the availability. Then the C here is competent, right? There's a lot of different organizations. You need to figure out what to do, what are the court processes, how to submit documents digitally. Does your appointed executor know what to do or not? If they don't know what to do they at least know how to find out what needs to be done? If not, they just sit on it, right, and wait, and hopefully things happen, right? And that's not so ideal. If they don't do a good job, they don't track the monies properly, the monies they receive put into their bank account, their monies also put into their bank account. After a while, don't know whose money is whose, right? And that's where losses can be incurred as well. So you want somebody that's competent, who can track things properly, manage the accounts of the estate properly. And the next criteria is you want to find somebody that is has no conflicts, right, or independent. Very often you have the situation where you pick some, you hear that I'm going to pick my oldest son, oldest daughter to handle the estate. My oldest son will know what to do, how to look after these other siblings, right? And so the oldest son becomes the executor, maybe becomes also the main beneficiary, and then the spouse will start whispering to that son, hey, things are not so good right now. Why are you going to keep so much money for your siblings first? Why don't we just make use of it to get rid of our debt first, and then I'm sure your siblings will understand, right? So there are all these potential undue influence, and so you want to pick somebody that has no conflicts, right? Independent, who can act fairly to all the beneficiaries and not favor some over the other, right? Or be influenced to favor some over the other. And so that's where potential conflicts can arise. And the last criteria is trustworthy, right? End of the day, every single asset that you own in your name, right? Bank account monies, insurance payouts, real estate investments, everything that you own will be under the control of the executor. And when I say under the control, means they can spend the money at will, right? All monies will go into the account that they are the signatories for. They can write a check, make a pay now transfer to whoever they want to. They can do it, right? Because it's all under their control. So the room and scope for abuse is significant. Do you trust them to look after your beneficiaries, to act in their best interest, when the beneficiaries themselves may not be aware of what's going on because maybe they're minor, right? Maybe they're not so competent financially. Do you trust them to do that? So essentially, you want a executor that's willing to act ACCT and act on your behalf. Okay. So in terms of possible candidates, right, these are some of the common ones that people will pick. Right. More often than not, people will still pick family members, but for them, their criteria is only, I'm going to pick people based on I trust them, I know them. So my spouse is going to be the one, my siblings are going to be the one, or I pick an adult child to be the executor. So what I typically do is have that dialogue, right? Help them to understand, okay, if I pick my spouse, do they meet the act criteria? Are they able to act independently, act competently? Are they available to handle all the things that need to be done? Are they trustworthy? Because many clients just focus on the trustworthy part. I trust this person, but may fail the other criteria, right? And that causes potential problems. So in terms of planning for executors, what I normally do is, for some clients, they recognize, oh, it's such a difficult role. I don't want to burden my family members to deal with this. And so the solution for them is straight away go with a corporate executor, right? So we go with like Precepts trustee to be the corporate executor, right? For some clients who feel that I think, oh, corporate executor will have to pay, I want to save some money, so don't pick corporate executor, let's pick my spouse first, okay? So it's okay for them to still pick their family members. As I said, the objective over here when we have this dialogue with the client is not about pushing them to pick Precepts as a corporate executor, right? We're not trying to do that. At least that's not my goal, right? Rather, the goal is to help them to make an informed decision, to understand the pros and cons. If they pick lay executors, right? They're not competent, they're not expert, things can go wrong. Are you able to afford the kind of potential mistakes that they can make, right? Will your beneficiaries survive the incompetence or the lack of proper execution of the estate if that happens, right? What are the things that can go wrong? But if they still decide to pick family members, make sure you have sufficient redundancies over there. So maybe spouse first, spouse not around, maybe a sibling step in. Then always, I would normally recommend for them to have a corporate executor to be the final corporate executor as final substitute, right? This gives your lay executors a way out. If they can try to execute first, because they don't know it's so difficult, if they start executing and realize, hey, this is too much work, I cannot do this anymore, they don't feel guilty about not doing it anymore. They can give up the responsibility, and it falls back on a professional at that point to step in. Okay, so to me, in my mind, when I think about executors, start off with a professional. If they are not comfortable with that, go with lay executors and then a corporate executor as a final option, right? And so for each of you, as you are going through this part, think through all these criteria as well, right? In terms of responsibilities, you have attended the Precepts course, so you know it's a significant onerous responsibility for the executor. We've talked a bit about the act criteria, right? Who to act on behalf of the estate. So for each of you, who do you trust to do that? If you have nobody to trust, consider a corporate executor. If you have some family members, write down your names inside the form. I think you can refer to page, is it here? Okay, this is the framework, so not suitable. Maybe refer back to this one. Your estate planning framework. The middle section here, there is your executor and guardian. So this top section, you can refer to that and use that to write down who are your executors, who's your primary executor, right? And you may have some initial choice. Please make sure you ask permission from that person, right? And please let them know that are you comfortable with the role of the executor? Explain to them what is required of the executor role, right? And then get their consent, right? Don't, hey, surprise, I'm dead, please take over everything. It's not a pleasant surprise. Okay? So spend some time thinking about that for yourself and write down some possibilities. You don't have to finalize that, right? At least write down some possibilities, and then please approach them and ask their permission. Okay. Now, even though they may have accepted the appointment at this point in time when you ask them, as I said, they can always give up the responsibilities halfway, right? Or at the point in time when you die, the circumstances may feel that don't really want to do. I'm not comfortable to handle this right now. So they can also give it up at that point in time, right? That's why having the corporate executor as the final option is quite critical, right? Can you remember what happens, right? If all the lay executors that you have are unable or unwilling to act, what happens then? LAWA, right? And what does LAWA stand for? Yeah, letter of administration with will annex. Right. So what that means in English is that when you pass away and all your executors are unable or unwilling to act, unable means they could have died, they could be mentally incapacitated, they could be bankrupt, so unable. Or unwilling simply says, I don't want to do it. Right. Bottom line is that all your appointed executors are not there to act on your behalf. The courts, then the family members will have to pick an administrator. And how do they decide that? They follow the letter of administration process, hence the term LAWA, right? Letters of administration with will annex. You end up having to potentially find 2 administrators, 2 sureties, and so that adds complexity to the estate process, estate admin process, right? So having a valid and viable executor is very critical to remove that complexity. So you want to do as much as you can to avoid LAWA. Okay, don't be LAWA. I think that's good saying. It works in many different ways. Okay, so if you're not, please write down inside your own notes section who you want to pick and then talk to them. Okay, then moving on to guardianship. So again, we're going to look a little bit about the responsibilities, candidates as well as trustees. So we've briefly looked at it earlier, but we'll spend a bit more time going through a bit more detail. So again, this is only applicable if you have minor children as in your estate, right, when you pass away. Right? That means children that are below the age of 21. If all the kids are above 21, then you don't need a guardian anymore. Okay, we went through this a bit quickly, but I'll spend maybe a bit more time just to refresh this conversation over here. By default, the surviving parent is always the guardian, right? So we don't have to name the surviving spouse as a testamentary guardian within the will, right? It's always there. The question you need to ask the client is, do you need a testamentary guardian to act with the surviving parent or not, right? If you're happily married, probably the answer is no, right? Unless, I don't know, you have a lot of kids, then maybe the surviving parent may need some help. But if not, chances are you don't need a testamentary guardian. You need, the second case is where both parents are not around. So the 2 scenarios we're looking at, or when the guardians will step in, is really about these 2 scenarios here, right? When will the guardian step in? Only with surviving parent or act on demise of both parents. So this scenario is probably more applicable if perhaps the husband and wife are on bad terms, maybe they are already divorced, and so the maybe current parent that has custody of the kids may not feel comfortable where the ex-spouse has sole custody of the kids, right? So he or she may want to appoint somebody else to act jointly. So this is where I can say, I want that spouse to act together with me, act together with my ex-spouse. Okay, so that's still a testamentary guardianship, but you indicate when that person will step in, right? Upon demise, upon my own demise, and I want this guardian to take over. If you're happily married, that may not be necessary. So in that case, you're looking at likely the second scenario, act on demise of both parents, right? So essentially, if you're happily married, probably when the guardian steps in will be this second scenario. If you're perhaps divorced, then maybe this scenario, right? What you have to remember is that you cannot extinguish the parental rights of the surviving spouse, right? Or rather, the only way to do that is not through a will. You have to go to court and provide evidence to the court why that person should not be guardian. Okay, typically that involves proving some kind of abuse and stuff like that. So it's not just say, I don't like his face, his parenting style, don't agree with mine. That's probably not enough. Okay. So in a will, the best we can do is to appoint a testamentary guardian to act jointly to represent my interests in the upbringing of my children. Okay. Right, because if they don't, then the third case comes into play, right? Guardian ad litem, as I mentioned, if they don't write a will, right, or they did not consider naming this testamentary guardian, then the courts will be the ones that will appoint a guardian if necessary, right? And so generally, parents should be in the best position to pick the guardian, right? So how many of you have kids that are minor still? And this is very relevant. In fact, this is a very good starting conversation to have with people, right? They haven't done their wills. This is a good way to start, right? As mentioned earlier, help them realize they have this problem. So our value add to the clients is to help them understand the role of the guardian. What do they do, right? Which is these 4 things we mentioned earlier. Okay. So they have overall custody of the kids. They're responsible for them. Any legal issues, the parents have to deal with it. Then in terms of support, financial support, feeding the child, clothing the child, providing shelter for the child, that's what they're supposed to do. That's what we mean by support and maintenance for the child. They also make decisions regarding education and medical needs of the child, right? If there's a medical treatment that's required, the guardian has to be the one that steps in. Now, on paper, right, on normal circumstances, the guardianship may not seem like a big problem, right? I give you a typical scenario. Let's say husband and wife, common disaster, both pass away. But they're staying with the grandparents, right, of the children. Right? So maybe the parents of the wife, let's say, is staying with them. Now, things may still carry on as per normal, right? Once both parents pass away, the grandmother could still be the one that brings the child to school. Everything still functions as per normal, right? And so the apparent lack of guardianship may not seem like a big problem until it's required. For example, the child meets an accident, right? And then now there has to be a decision made. What treatment to do, right? If we take this course of treatment, the child may lose one leg, they do the other side, maybe something else will happen. So somebody's got to make this decision, and it has to be the guardian. Now, is the grandma the guardian? It's not. So the grandma can't make the decision. It ends up becoming potentially an independent panel of doctors that will make the decision for this child, right? Which may not be aligned with the family's values or whatever. And so that's complicated. So the problem is when you need the guardianship and you don't have it, that's where the problem happens. Under normal circumstances, it may not be apparent, right? So you don't want to wait until you suddenly need it and you don't have it, just like insurance, right? By then it's a little bit too late to deal with it. Okay, so it's important to name this guardian appointment within your will so it's dealt with. So these are the other conversations you have with the client to help them understand their guardianship, which is this issue of guardian and trustee, which we talked about. So I will skip this part. So in your own case, if you have children in your estate, who is the guardian? Should the guardian and trustee be the same party? When should the guardian step in? These are the questions you need to have in your own, ask yourself, and also ask your clients eventually, right? So who is this guardian? Unfortunately, in this case, unlike a corporate executor, we have no corporate solution. We can't say precepts to look after our kids. They don't do that. So it has to be your own family members. Okay? Now, this can be a bit challenging, especially when you're dealing with families that have been naturalized. They were from other countries, and so their extended family is not here, right? A lot of times, as locals, we can turn to our extended families, siblings, parents. But for people who have moved here from overseas, their extended family may not be in Singapore, and so that becomes challenging, right? And this is where having this conversation earlier, right, is also very useful for them because they may not be aware of this problem in the first place. And so by having this conversation, they realize, hey, I got this gap in my situation right now. If something were to happen to me and my spouse, I have no one else to look after my kids. Who can I turn to? So this is where they will need to maybe start thinking about building relationships with some locals over here, right? Maybe their neighbors, maybe a good colleague at work. If they're part of some religious organization, maybe the church, the temple, their mosque, they can reach out to these parties to provide this support for the kids, right? And this doesn't happen overnight, right? You're not going to say, hey, if tomorrow I die, can you just take over my kids to your neighbor, right? It's not going to happen. It takes time for you to build a relationship, right? But if they don't start this right now while they're still alive, there may not be that time to build that relationship. So having this conversation earlier gets them to think about this issue and to think of some contingencies, right? So possibilities are parents, siblings, and just like we said, effective will, we talk about contingencies, right? You don't just have one guardian, you have substitutes as well. If guardian A is not around, guardian B takes over, or you could have a joint guardian. I want guardian A and the spouse of guardian A to be my joint guardians for my kids. If they're not available, then I want guardian C to take over and C's spouse as well, or something like that. So think about the redundancies as well and make sure that they're all documented within your wills. Okay. So please think about your own case. If you have children, who do you want to pick as guardians? Okay. Okay, frankly, I don't see anybody writing, so can't be helped. Okay. For those of you who have not done your will, the purpose again is to get you all to think through this and write it down. Yeah. Okay, so this form doesn't have that actually. So you can actually use this framework here. I think it was given out to you. It's under the middle page. All the appointments are over here. The delegate part, the who part. So you have executors on the top, then guardians at the bottom. So you can use this framework, this page here, to write down your instructions. Even write down possibilities, right? I mean, you may not be finalizing today, but you write down some possibilities, people you want to ask permission.
A year to come back to me to get the surety, you know, because nobody wants to be surety. What I don't say is true. Surety first.
Because there's a minor, there's a child.
Or we go, but I'm not sure how.
Yeah.
What chance.
Only two, right? As I said. By default, yes. Surviving. So that will be the primary guardian, because by default the spouse will be the default guardian. Right? If she passes away first, then her husband will automatically be guardian. So the question for her is, does she need somebody else to act as a surviving spouse or not? If she's happily married, chances are the answer is no need to, right? I would think so, generally speaking. Yeah. Yeah. Sure. So this is where we talk about the scenario, right? Should it be the same parties? If you put together, no check and balances. If you need check and balances, then separate it. Yeah. Then it's a matter of who should be a trustee. Is it a family member or you go with a corporate solution? Because for a kid, depending on how old the child is, it could be a multi-decade kind of arrangement, right? Yeah. So you're talking at least 10 years. Question is, after 10 years, money still there? No? How much money is left? Who's tracking? Yeah. That will be my starting point usually. Yeah.
confident maybe the wife can do very well, appoint the father as a joint guardian. So in the will, the husband also have to write down.
Write down my brother. Don't have to write a task because again, guardianship will be this whole list of things that they're supposed to do, right? Automatically, is that just that they supposed to work together and make decisions together. As guardian, they do all, right? How they split among, how they actually work operationally will be between the two of them to figure out, right? But so they can split that way, but it'll be between them to figure out, to work it out themselves. Okay. So by default, guardianship means you do all this. So you cannot say that only do half of it. Yeah.
Why do I mean,
no, I don't think so. No. Yeah. You're saying that you don't want the wife to decide what school the child goes to. A bit hard, right? I mean, how can you say I'm the mother and I cannot do that? Right. So they still talk, but maybe one party they will need to discuss and come to an agreement. But you cannot, as a guardian, they have all these responsibilities, yes. If they need some more control, then they may need to draft out some kind of deputy. Deputy doesn't. I'm not sure if a deputyship type of arrangement might work in this kind of scenario. I'm not 100% sure. May need to talk to a lawyer if they have this kind of concern. Yeah. Okay, but the will, at most you can do is appoint a guardian, and the guardian does all this. So you cannot restrict it to only certain parts of this responsibility. Okay. Right. So look after the money, look after the child, kind of the difference. Okay. Okay, the next part we're going to cover a little bit more is, and I don't think we're going to finish everything in time, like 30 minutes more. We'll go through a bit of distribution strategies. And this goes back a little bit to this tree, right? So we have this tree over here, but we'll elaborate a little bit more by covering other issues. Okay. So this slide elaborates on this form of distribution, right? We have these basic ones in the will, but there are other things that we can also do. For example, we can do a lifetime distribution, right? It means give for your life. So you have certain collections like watches and jewelry. Instead of waiting till you die, why not give it now? That's a viable option, right? So as you're talking to the client about how to distribute their assets, and you look at them having collectibles and like paintings and stuff like that, jewelry, one option is to give it during a lifetime. Is that viable for the client? Because then it's probably easier. The beneficiaries get to receive the item. You can see how happy they are. That might actually be a good idea to give it right up front. Okay? But the trade-off, of course, is if you give it up front, what's the problem with that? You lose control, right? Once you give, it's not yours anymore. And so they take, you ask them to keep it, hang it up in your house, then they take and go and sell it. And that could happen. So once you give, you lose control, right? So that's one of the problems. Okay. The other way is don't give in a lifetime, then give only when you die, right? For most people, whatever assets they have, they probably want to use it for themselves. When they're not around, that's when they give. And so one way to do that is to give via the residuary clause, right? That's where you give your 50 to spouse, 25 to son, 25 to daughter, or 100% to spouse not around, and give to children 50-50 each or whatever, right? So you give that percentage, and we do that via the residuary clause, right? So what is the lowest priority give? For most of the time, when I do planning, I start with the residuary clause because it's usually the main form of giving to the main beneficiaries, right? Because it covers everything that you don't specifically list down. right? In your will, you don't have to list down all the assets you own, right? That's why residuary clause is always percentage, is to cover everything, right? Because it's percentage, it also causes problem because not everything would make sense to distribute via the percentage. That's why we will deal with it later through a specific gift, which is the next part here. So like real estate, right? Real estate, I can, if I'm the sole owner for the real estate, I can give all my real estate proportionally, right? Or in that percentage, 50 to spouse, 25 to son, 25 to daughter. Problem is that I got a bunch of owners who may not agree on how to deal with it, and that causes the problem. So in this case, I may choose the second, a different way of handling that. I do a specific gift. Give the whole property to one party. Don't give it to a bunch of people, because if I leave it to the residuary estate, it gets split 50 to spouse, 25 to son, 25 to daughter. So that's what I mean by dealing with problematic assets. When I look at the list of assets the client have, identify the common ones that are problematic to deal with via the residuary clause. Of course, it really depends, right? If, for example, my instructions are, if I die 100% to spouse first, then it may not be a problem, right? If my investments go 100% to my spouse and my spouse is financially savvy enough to manage it, I may not need to do a specific gift for the investment account, right? But if my residuary clause says 50 to spouse, 25 to son, 25 to daughter, and my spouse is not financially savvy, or maybe she is, right? But then half of the investments end up going to the kids, which are too young to manage it, then it may not make sense. So I may want to write a specific gift and say 100% of all my assets go to my spouse instead, rather than to leave it via the residuary clause. You get it? So transfer upon death is free of stamp duties. But of course, the problem is that is the other issues we need to think about, right? Which is if they do get it, suddenly all of them become co-owners. If they can't agree on what to do with it, then that causes a friction between all the beneficiaries. Okay. Let me open it to the floor. Can or cannot? Don't give it to yeah. Okay, and yes, and the way we do that is called testamentary trust. Yes, so I give the benefit but not the control. I let them stay, but they never own the property. Once they pass away, then I give it to somebody else or let somebody else benefit from it. No. So again, that's the best way to transfer property into a trust. It's free of stamp duties. No 65%. If you do it yes, upon your death. So you got to write your will to do that. And that's the most cost-effective way to do it. If you do that in your lifetime, 65% ABSD. While you're alive, you transfer the property in a trust, you pay 65% ABSD to do that. But if you do that through a will after you die, 0 stamp duties, 0 ABSD. Yeah. Sure. No. Nobody, doesn't matter who the beneficiaries are, as long as you transfer via a will, it's free of stamp duties.
If you want to buy property, they cannot own the company, and you get trust.
So it's possible. There are some requirements for such a trust structure, but it's possible to avoid ABSD. You do have to pay first and then claim it back subsequently, assuming you meet certain criteria. Things like the trust must be irrevocable trust, the shares must be fixed shares, and the beneficiaries cannot have a beneficial interest in any other property. If you meet those criteria, then yes, you can get a remission of your ABSD back. Okay, so the next two forms of distribution, right, other than lifetime gift, are done by the will. But again, these two forms are the ones where we give, again, lump sum, right? That means once I give, it goes 100% to that beneficiary. And problem with that is once I give it, I lose control of the assets. So the other forms of distribution we see at the bottom here where we can use some kind of trust structure, right? Where we give the benefits, but not the control. So the next part is staggered conditional gift upon death. So this is via a testamentary trust. So what I mean by here is staggered means I don't have to give all at one shot, right? Because if I give everything at one shot, the beneficiary receives a lump sum, they could spend it unwisely, squander it, invest it poorly, and lose all the inheritance. So staggered means I give it over time, right? I give you $10,000 a year, and this will last for the next 15, 20 years or whatever. Okay, so that's staggered. It can also be conditional. That means only when you meet certain conditions, then you receive. For example, you must be gainfully employed or studying full-time, then you receive that $10,000 a year. If you are bumming around at home, when you are not studying, you're not working full-time either, then I don't give you anything. So you can impose these conditions, right? So that's the way to handle that. Then the last form is another variation of a trust via a living trust. And so this is where we can impose other kinds of triggers, right? In the first case, because it's distributed via the will, it can only take place when you die. But if I want to deal with certain life events like loss of mental capacity, then I may need to use a living trust. So when I lose mental capacity, I coordinate that with my LPA, right, and direct the assets into the trustee, or corporate properties and affairs don't need to take over my assets at that point in time. Okay. So these are the different forms of this ways of distributing assets. The question is, how do I decide which ones to use, which is appropriate? So I have these 8 criteria that for you to keep in mind when deciding which form. Okay, it's not a one-to-one mapping. So these are just some things to keep in mind. For example, the first one is about legal enforceability. A lot of times people do the informal method, as I explained, right? We give to one party and then says that party will know what to do and how to take care of everybody else. The problem is there's no instructions. And as far as the legality of that goes, it belongs, that gift goes to that person. There's no clear responsibilities for that person to use that monies or the assets or inheritance for anybody else, because the gift was to him, right? So it becomes an informal trust, and there's no legal enforceability. The other beneficiaries try to sue. You can simply say, the will say give everything to me, so it's mine, right? And that's the problem. So many people try to do the simple way, cheap way, and they say, my family members will know what to do. This is a potential problem, right? We want that legal enforceability to give legal recourse if the beneficiary doesn't get their rightful share. So legal enforceability is one thing to keep in mind. Typically, this requires some kind of transaction cost, right? You need to set up some kind of legal documentation or legal structures to enforce that legality, right? So your instructions to go in a will, you have to pay for that will. If you want the control to be more, to handle other situations, you may need some kind of living trust. So again, you have to pay for the living trust kind of instructions. Okay, so there's usually some kind of transaction cost involved with executing those instructions, right? For example, if I have a property which I want to transfer to a trust, I may have to pay ABSD right now, right? I'm worried that if I want to give this property to my kid during my lifetime, then I have to pay ABSD or pay some kind of stamp duty to transfer to him. If I give it to him via trust, I have to pay ABSD for that. So there's always some kind of transaction cost. And the problem is sometimes when we make some of these decisions upfront without considering the estate planning implications, to unwind it, it can be very costly. Okay. Another example would be I structure my investments or structure my property holdings, right? Because I want to buy a second property, avoid ABSD. So I do a decoupling of the property. Everything goes to my spouse, and then sounds like a good idea, so that now the husband is unencumbered, can buy a second property until they have a marital problem. Then suddenly he's lost his property, right? They never think about that. And if I want to change this, wife have to retitle the property under the husband's name and then end up paying stamp duties for that. So it becomes very costly to unwind some of these mistakes subsequently, especially when you've got to do with real estate. So yeah, hopefully the client will talk to you about such issues before they make their decision to buy a property or whatever. Okay, there's also certain tax implications where you make certain decisions. If you invest overseas, there could be estate duties, there could be inheritance taxes. If beneficiaries move to certain countries and take on citizenship over there, there could be inheritance taxes that you have to pay for them. So there's certain tax implications when we make certain investment or certain decisions on our assets. Okay, next thing to consider is beneficiary benefit. When I make a gift to that beneficiary, did I actually benefit the person or not? Right. So one possibility over here is that if I make a gift to, again, let's say use investment accounts. If I give the investment account to my kid, does my kid actually benefit from that gift? Do they become smarter, wiser, richer? They also don't know how to invest, hold all the way to zero. And then did I actually benefit them? So I may not have benefited them, right? So when I think about making a distribution of certain assets or my inheritance, I got to think whether that gift makes sense from the beneficiary's perspective. Did I actually benefit that person? Okay. Or in the worst case, I make a gift and it could have negative benefits, right? If I give $2 million to my son, after that he receives $2 million, he will say, oh, I'm rich. Why go and study so hard for? Why go to university? I can stay at home, play computer games for the rest of my life. I can become a pro gamer. If I don't make it, never mind. It's still okay. I can still continue playing because I got more than enough money, right? $2 million invested at a conservative 4%, that's $80,000 a year in yield. I don't really need to work. Not very rich, but pretty comfortable, isn't it? So then I have created a trust fund baby. Is that really what I wanted? I've spoiled my kids, spoiled their motivation to work, taken away his interest in furthering himself. And so did I really benefit him? There could be certain negative effect. Or another example is they receive the inheritance, they buy a sports car, drive it recklessly on the road and kill themselves, or injure themselves, become paralyzed for the rest of their life. So bad gift again, right? So these are things to keep in mind. Will the gift have a negative effect on the beneficiary? How does it spoil them? How does it affect them negatively? Okay. Other things to keep in mind is the complexity of the instructions. How complicated do they want their instructions to be, right? If it's simple, maybe using a will to distribute the assets is good enough. But if the client says, my situation is a bit complicated, maybe I'm going to get married, maybe I'm going to have kids in the future, maybe I'm going to move to Europe or whatever, and there's a lot of uncertainty. So there's a lot of scenarios you need to plan for. Then you want to use a more flexible tool, because every time they make changes to a will, it's going to cost them money. So maybe a tool that is flexible to change, like a living trust, might make more sense to handle that. Or I'm planning for many years into the future. It's very hard to anticipate what's going on, right? I want to make provisions for my grandchildren. They don't exist right now. My kids are 2 years old, but I'm planning for my grandchildren already. So that's complicated. So a will may be less suitable for that kind of complicated instruction. So a trust structure, living trust, might be more appropriate to revise things as we go along. Okay. Or you got family in Batam that you don't want your family in Singapore to know. Yeah, that's also complicated. Next, privacy. Yes, family in Batam. You also don't want your family in Singapore to know about your family in Batam, right? So using a will to distribute your assets to that family in Batam, not such a good idea, because your family in Singapore who are also beneficiaries will see that, and then they'll start asking, hey, who is this party who's getting it? Indonesian IC numbers are more. So not so pleasant. Okay, so a living trust again is more private. You can, and sometimes the issue of privacy is also about keeping the harmony within a family, right? If I receive $1 million, I'm happy. But if I know you got 2 million and I got 1 million, suddenly I'm unhappy, right? So keeping that privacy to not let let each different beneficiary know how much they get relative to each other is important. Then privacy might be critical. So we use some kind of trust structure to avoid revealing too much. Okay. Final criteria here is asset protection. Does the client need asset protection? Okay. Does the beneficiaries need asset protection? So if I am worried that my assets are lost to my creditors, I can't use a will to just handle my assets. I need to hold it differently. I may need to transfer it to an irrevocable trust, so it's not my asset anymore. I can't just use a testamentary trust in a will. if I need to protect the beneficiaries from their creditors, then I need to use a discretionary trust, right? Either testamentary trust or living trust, but the trust share must be a discretionary share, so they don't have an entitlement, and so creditors cannot come after that share. So being aware of all these different criteria will help us choose the right form of distribution. Okay. Okay, so now let's talk about residuary clause. And for me, when I do planning for the clients, I always start with the residuary clause, right? I want to, because that helps me identify who the main beneficiaries are and whether it causes problems that I need to deal with via the specific gift, right? Again, the example I gave is if I'm giving 100% of my assets to my wife first, and my wife is not around, then my substitute are my kids, then I may not need to deal with the investments separately, right? I'm comfortable to give 100% to my spouse because she can also manage my investments. But if I'm giving 50 to spouse, 50 to 25 to son, 25 to daughter, and my kids cannot manage investments, then I may want to deal with my investments in a more appropriate manner. Maybe 100% all to the spouse, right? Or 100% to a trust, and then it's professionally managed, or whichever form. Okay. I think in this handout, there is this part at the back, which you can, I think, consider. Yeah, I guess you can name your beneficiaries. Under the last page, under your beneficiaries, this looks a little bit like your residuary clause, so you can consider using something like that. So for me, what I typically do for the planning in this case, when I do a fact find, right, part of my process is I will hear from the client, I'll get the list of their assets and beneficiaries before I meet up with them, right? That's my step 2, right? Step 1 is pre-sales. Step 2 is I do some prep, and part of the prep is for the client to fill up the list of the assets and the list of the beneficiaries and send it to me. So once I receive that, usually what I'll do is I'll construct an initial, what I feel is a reasonable residuary clause, right? And here's an example of what it looks like. Okay, so this is a beneficiary listing. Okay, we'll come to that structure a little while in a while. But when I'm thinking about the residuary clause, one of the things I need to keep in mind is to look at who the beneficiaries are and to identify any potential complexities dealing with those beneficiaries, right? So if I'm giving to spouse and kids, then I want to know whether are there potential mental incapacity issues, right? Because if there's a beneficiary who's MI, right, maybe a spouse or an elderly parent, for example, then they legally cannot receive the inheritance. So rather than give to them directly, I may want to use a trust structure to give to them instead. Or maybe they're spendthrift, right? If I give to them directly, then they'll spend everything. So I don't want that to happen. So again, don't give lump sum, give through a staggered approach. If they're bankrupt, then the risk is that their assets are lost to the creditors. Again, I may want to use a discretionary trust to give to them so they don't lose all their assets directly. Or I'm worried about them being delinquent, right? Then don't give the assets directly to them again because they will squander it and use it unwisely for drugs or whatever else. So that's a concern, right? Other criteria here will be whether their special needs is vulnerable. So by reviewing all these conditions, I can then decide what's the better way to give, right? Instead of giving directly, right? That's the easiest way, but it may not be suitable. It may spoil the beneficiary, the assets may be lost. So I don't give directly. I may want to choose a trust structure, right? Then it becomes whether testamentary trust or living trust with precepts, or the special needs, then I have the special needs trust, which I can also use. Identify which form of trust makes the most sense, right? Because end of the day, the residuary clause works this way. Whatever stuff goes in, right? Everything I have by default is my residuary clause, right? All my assets are first used to pay off my liabilities. So creditors have first right on the estate, and so that's your number 1 here. So after that has been paid off, then my specific gifts are next. Whatever specific gifts I have will go to them. And then my residuary clause is finally whatever is left goes to my residuary beneficiaries right at the bottom here. So it's always going to be a percentage base, and this is a typical example. So a structure I would have by default, once I understand their beneficiaries and conditions, I will come up with an initial structure. For example, maybe give 100% to the spouse not around, and give to children not around, give to parents on both sides of the family, right? And then finally, if there's nobody else, give to charity. So I'll come up with an initial residuary estate, and this is very helpful because it helps the client to have a working copy, right? Rather than to start with a blank sheet and then they start thinking of who to give to. So I start with an initial template, right? It could be 50 to spouse, 25 to son, 25 to daughter. Spouse and kids not around, then give to parents and siblings. Parents and siblings not around, give to charity. So an initial structure. So if you're a typical family unit, that's a good starting point. But if you're single, then it becomes a little bit more complicated. That's where having that listing of beneficiaries allow you to come up with a reasonable starting point. So I realized that helps narrow down the planning to a conclusion much faster, rather than so who would you like to give to? When you have that opening conversation, which I used to do, you can talk about it in hours and hours, then they'll think about many different scenarios. In the end, after 3 hours, they still don't have a distribution. Okay, so I start with something and then ask them, is this okay? It's much easier for them to say, yes, okay, not okay, then change accordingly. Okay, so that helps. So that's why if you've done the planning yourself, it's a lot easier because you've seen all these kind of beneficiaries. You can apply your basic way of thinking to that scenario. And then, of course, your client may have slightly different values from you, and that's okay. But they have a starting point. And it's a lot easier to just vary what you have and just move along that lines. Okay. So in terms of the criteria, what I look out for is in the residuary clause, I want to make sure that there's sufficient redundancies. I'll make sure that contingencies are taken care of. Okay. So make sure that all the whatever tier that I'm in. So if like first tier, 100% of spouse, everything is 100%, that's great. For the kids, the second tier, right? If spouse is not around, then give to the kids. Then kids will make sure that the total always adds up to be 100%. Okay. So in terms of contingencies and redundancies, the first part here talks about having sufficient redundancies, right? Many layers. Then we talk about how to handle contingencies in the form of some of these beneficiaries predeceasing. So again, the clients typically don't think about that. If you recall, in your EWF, you have your PRO, EQU, and all that kind of stuff. Yeah, this is where we use that. So I ask the client, right? So if one of your son, like in tier two here, son and daughter, right? If your son predeceases, what do you do with the share? Do you give to his kids instead, or do you want to give to your surviving children? Right, and then let them decide. So again, you can have some initial recommendation. Maybe give to surviving or give to children first. Children not around, then give to survivor. So that could also work. Okay, so have that initial plan and then explain to the client what you're doing so that they say, oh yeah, this looks good. Easier for them to just say yes. Okay, and finally, the last part here is consider some kind of ultimate beneficiary, right? What you're really trying to avoid in the case of the residuary clause is a very simple will, right? If the client does it themselves on their own without any kind of guidance, they will end up with something very simple like 50 to spouse, 25 to son, 25 to daughter, and that's it, nobody else. No contingencies, no what happens if spouse pass away, that kind of scenario. They don't think about anything. And so if a common disaster happens, spouse and kids all pass away and they have no substitutes, the estate is distributed via intestacy laws, right? Which is a pity because you spend all the time drafting a will and you still end up distributing your assets via intestacy. Okay, so the client probably will not think about all these contingencies, so it's our job as estate planners to suggest that. So in your own case as well, please think about this, right? Who are the key people you want to give to? Are you the 100% to spouse situation? So if you're giving the spouse, then some consideration will be, what if the spouse remarries? Are you okay with that? Some people are, some people are not. Okay. Even if you're giving 50 to spouse, 25 to son, 25 to daughter, some people prefer to structure it via a trust instead of giving directly. So these are some of the scenarios I'll bring up, acting as a devil's advocate to help the client think about these scenarios. This is our value add to the client. Okay. More often than not, it's the husband that thinks about the remarrying, but it's the wife, the husband that actually remarries typically, but it's the husband that thinks about it. Maybe that's why he's thinking about it. That's why he remarries, right? The wife, at least from what I see, typically less worried about it. Okay, so that's for residuary clause. As I said, while it's the lowest priority gift, it's usually giving to the main people. Then the next part here is thinking through specific gifts. Okay, there's about 5 minutes left. And as part of this planning, I will also go through the non-probate assets. For me, I keep this simple. I just tell the clients, have you done your CPF nominations? Yes, I have. Okay, good. That's it. Game over. I'm done. Okay, you can upsell a Provi Trust if you want. You can ask them how much money you have. Likewise for insurance. So there's definitely more things that can be done for insurance, especially if you're the servicing agent, for the client to review them, to make sure that the gist of all this is to make sure that the overall plans about who they want to mainly benefit, right? That's why understanding the residuary clause is important. If they're mainly giving to spouse, does all these other forms of CPF nominations, insurance nominations align with their overall intent? If it doesn't, then update it, right? Chances are they can't remember what policy they nominated to who. And so reviewing that and adjusting it as required, right? Again, these are all free service. Your client doesn't pay you for that. Usually I ask them to please get it done. And then it's kind of on their own, right? If you are the main servicing agent for the policies, then the proper way to execute that is make sure that the will is signed first before cancelling any of the nominations that don't work. You don't want to cancel the nomination and then they delay their wills and then end up not having a nomination. Okay, so execute it properly. By default, it will go to the surviving account owner. So the surviving account owner can go in and withdraw monies because legally it belongs to them. As long as the bank hasn't frozen the account, they can do that. Sorry. Typically, the bank would freeze because they want to assess the situation, right? In case this client who died owes money elsewhere, they still can take this money to pay off the liability.
Nominated. It will become a normal.
All the. So it depends on the nomination. If it's what you highlighted is for the revocable nomination, right? Then if all the beneficiary predeceased, yes, it becomes unnominated. But if it's an irrevocable trust nomination, Section 132 policy, then it will go to the estate of the deceased beneficiary. It doesn't get unnominated. So it's, in the case of a trust nomination, it is in life or in death. Estate, yes. So it's no different from an unnominated policy. Right? So unnominated policies just form part of the estate. Okay. So under the specific gift, I don't think I have time to go through individually because it's 5 o'clock already. What we're trying to do here is I just listed down a couple of different assets. So we talk about real estate, which is a problem. So once we have the list of assets that the client has, we go through each of them that has a problem and ask the client, right, what would you like to do? For real estate, there's a couple more things we need to deal with, things like outstanding loan. Is there any kind of MRTA, mortgage tied to it? And so we ask some of these instructions and how to deal with it. So unfortunately, we won't have time to go through each of these bits here, but we'll just move through very quickly what other things we cover. So businesses are also particularly problematic because they, while you can distribute it to a bunch of people, it just may not make sense to distribute it to a bunch of people, right? So in terms of business, you typically can give, sell, or wind up the business. These are the 3 options you mainly have, but each of them has a whole host of considerations behind them, right? It's easily another 1-2 day course on its own for succession planning. But if your client has business, then have a dialogue with them on that. If they have collectibles, right? Again, not easy to distribute. They can be sensitive, complicated to handle. So we want to ask them how to handle that. A good way to deal with it, we've learned in the course, is to distribute as per labels. So if you have watch collection, stamp collection, ask the client to label them, and the will can simply say distribute according to these labels, right? Because it's very hard to refer to these collections by describing it, right? If you got jewelry, it's very hard to describe the jewelry, right? Painting, a bit hard to describe. So these collectibles are difficult, okay? Overseas assets are also problematic. So here we list down all the different complicated assets and talk about how to deal with them, right? Whether it makes sense to still distribute via residuary. More likely than not, it will not be. So we be a bit more deliberate and talk with the clients about what best way to deal with it. And then for testamentary trusts, again, these are different scenarios where a trust will probably make more sense, where a beneficiary who is not very financially savvy, a beneficiary who has too much money and time on their hands, they can become a delinquent like this gentleman, or the gift can cause them harm instead, right? Where they spend it unwisely and cause them harm. So instead of giving to them directly, we give it via a trust structure where we can give the benefits, but not the control. So this simple workflow here are the main sections. If you look at the EWF, you can simplify it to these main things, right? We talk about who are the trustees to look after that. And by default, the trustee is the executor, right? But here you may want to choose somebody else, right? Your executor may be comfortable to distribute the assets, but to manage the trust for the next 5, 10, 15, 20 years, they may not be so comfortable. So you may need to split that. And if you're managing this for a multi-year period, maybe a professional, a corporate trustee might make more sense, okay? Then you list down what assets are there. And some good ways to refer to them is if you're giving to kids, for example, via the residuary clause, then you can simply say the children's share of the residuary estate. You don't have to list down individual items. So it's a very convenient way to deal with it. Okay, again, to save time, I think we have some other bits to cover. So that summarizes these main things. So when I'm talking to the client, I'm asking about this, right? Once I understand the residuary estate, what the client has, I look at the list of items that they have sent to me beforehand, which are the ones that are problematic. If I'm not sure how to deal with certain types of property, like the guy's got property in the Netherlands, what are the rules governing distribution of property in the Netherlands? Then I'm going to look it up beforehand. So that helps me prep. So we can then deal with it via the will. But these two are, again, outright distributions. If the client needs a bit more control, then either a testamentary trust or living trust might make more sense, right? So that's typically what I go through in terms of the fact find. So in summary, okay, so this is what we do for the pre-planning. Long slide here. Oh, sorry, this is supposed to be the practice. Okay, we don't have time for practice anymore, so practice on your own, right? How to position yourself, how to, again, if you can't remember all this, hopefully you took some pictures, or actually all this content is actually in your slides from precepts, right? It's not new, it's just organized in a slightly different way. So in summary, what we've done is we've talked a bit about how to have that pre-sales conversation, right? The 4 key points: position yourself, help them recognize they have a problem, solve the problem for them, and overcome their objections, right? That's your pre-sales conversation. Then we've gone through how to do the planning, which is this 5 key things I'm trying to do in my fact find, understand, use the content you've learned in the course to dialogue with the clients to help them decide how to distribute this, how to handle their distributions and their will, and you should be doing that for yourself. Yeah, and then we conclude it, okay? So with that, sorry, I didn't adjust the time more appropriately. Just want to hand this time back over to
Okay, thank you, John. Let's give you a clap.
Frankie.
Thank you for sharing, John. Okay, if you can, maybe just take another 10 minutes to fill in the estate planning framework, the blanks, the positioning, the guardian, executor. At least you get something thinking first, right? So you won't be just a knowledge-based time for you, but you really have a hands-on practice for yourself, and also need you all to do a feedback. So yes,
Yeah.
Sorry, before you all go, just scan this QR code, do a feedback.
Yeah, sure.
And also take a class photo.
Mhm.
Before you all go, take a class photo
Okay.
with us. Thank you.
Sure.
Okay, please scan this to get
If he has
feedback.
if he has a living trust already, there's probably no need for a testamentary trust unless he has different objectives. So in that case, the consideration.
Please help us, give
what
us
the CEO will
feedback.
do at
Thank
the
you so
end of the
much.
trust. Because again, in the trust part of the course, we learned that if the final intent of the client is at the end of the trust, right, is to transfer the property to the beneficiary, a testamentary trust, the final leg of transfer is free of stamp duty still. But if it's a living trust, the final leg of transfer to the remainder man beneficiaries is you have to pay ABSD, normal stamp duties for the beneficiary. So that's a important consideration. If the final intent is to transfer the real estate to the remainder man beneficiaries at the end of the trust, if you do a living trust, you have to pay the beneficiaries have to pay stamp duties for the transfer. The client is already died. Yeah, you write your will, transfer to the trust. Yeah. Yes. Still, yeah, because it's transferred via the will. Yes. Assuming the property is totally owned, right? Because if it's yes. Right. So the question, because there's two options, right? You can give the property straight to the spouse, you can put it into a trust. The client has to decide which one makes the most sense, right? Giving to the spouse, the risk, of course, is that the property can be given to the remarriage and stuff like that. Yeah, sure. Yeah. Plus, it's the most cost-effective way to put into a trust. So if you have the option to put in a trust, it's to be good. Then you can benefit a bunch of people and change that as you go along, so it's flexible.
There's no ABSD, but I have to pay stamp duty.
So from the will, if I transfer from the will to the trustee, a living trust, right? Living trust, right? It's free of stamp duty first because it's still, the transfer happens because of death, right? Via the will. But because now it's in a trust, when the trust ends, and the trust will end because maximum duration of a trust in Singapore is still 100 years. So, or all the beneficiaries die or whatever, right? Once the trust ends, if the instructions of the trust is to transfer the property to your remainder man beneficiaries, right? Remainder man means your the end of trust, the beneficiaries, right? When I do that leg of transfer, the transfer now is not via death anymore, right? It's via a living trust instruction. So you pay stamp duties. The buyer or the beneficiaries have to pay stamp duties for that transfer. They are like the buyer. Because for testamentary trust, right? Because all the instructions come from the testamentary trust, which is part of the will. So it's still deemed as transfer upon death, and so no stamp duties. Okay? And yeah, sure. See this line? Okay, battery is not it's normal. Maybe energy goes where the battery